Supplementary list, item number 1.
Yes. Do we allow 2 weeks time for filing the other affidavit, but we wanted a report with regard to the repair of the Joy bypass? If you see last order.
Giving the copy of the court. You should be given the copy.
Copy of the Joy bypass.
No, sir. Deputy Commissioner.
Yes. Any inputs from your side?
Yes, sir. Your Worship, if I misspeak, I'm the petitioner. As far as Joy bypass is concerned, yesterday I was traveling and some progress has been made and backtopping has started, Your Honor, much comparing to the other years, other months, Your Honor. But as far as the other concerned, 896 from Lumshnong to Maledar, which yesterday I have gone.
896, they have to file a report. Give them 2 weeks time. Yes. That's the record. NHI, your report been filed. After you file an affidavit.
Yes, through an affidavit, I'll file an affidavit.
What about the state? The states will file an independent report on that
What should
too.
we have filed?
Is this one?
Pictures are there. You can see.
You give me a copy?
Lordship, Lordship, we annex the photographs also in case of any further suggestion, Lordship, we're going to act on it.
No, we do one thing. Let them go through the status report.
Absolutely.
Should we have it next Monday?
So, Lordship, if they have any further suggestion, they can communicate to us.
Else, have you traveled on that road?
Yes, I came yesterday. Yes, Lordship.
On what? In what car?
I went by a small car, Your Lordship.
Small car?
Yes, sir. At least potholes has been filled in most locations, Your Lordship. Just blacktopping is left.
Okay, just take down a status report on behalf of state government. Stroke Deputy Commissioner East Jayante Hills, in compliance with the order dated 13/11/2023 has been filed today by the a copy of the same made over to the petitioner who's present today in person. Stop. This is matter on listed on 20th for further orders. Yes. Copy of the report is
report also has already been brought on record.
right. A copy of the report is taken on board and made part of the record. Stop. Also noted, the NHI has also filed their affidavit. Yes.
Item number 2.
May I please, Lordship?
Yes. What is the progress?
Lordship, it is still pending in Supreme Court.
But this matter involves the question whether royalty is a tax or not, my lord, and whether GST can be imposed on royalty. The matter
Imposition of GST and royalty.
My lord.
So when's the matter likely to come up for the Supreme Court? Any idea?
No, my lord. Only the stay has been granted, my lord.
Yes. Okay, parties informed that the matter is still pending consideration before the Supreme Court. According to this is a matter of 6 weeks. Yes. To await any outcome. Yes.
Item number 3.
But here we have come against the order of the cat, my lord. This matter pertains to transfer of a postal employee, my lord, from Shillong to Tura.
Is it a fresh matter?
It was listed earlier, my lord.
There is an order of 20th September 2023.
Who's that?
There is an order of 20th September 2023 and another of the 30th of October 2023. Honorable Chief Justice did not interfere with the order of the tribunal, did not regard this day, and also further there is a direction to allow him to they are going to a settlement. Thereafter, my Honorable Chief Justice is directed to release this
Has been resolved.
My lord, actually, I could not pursue. I told them, my lord, that
No, last order.
instead of 2 hours, we can be transferred.
Please listen, Mr. 1 second. This is the last order says that you're ensuring that the issue involved should be resolved.
not resolved.
Not
My lord,
resolved.
it has not been resolved as of now, my lord.
They are not jointly, and he is not without salary since February 2023. With a daughter and a son, my lord, the entire family is suffering. So, my Honorable Chief Justice is directed to release the salary. They are also not.
Have you released it?
My lord, the matter can come. I could not pursue the matter, my lord.
Release it tomorrow.
My lord, tomorrow, Friday.
No, you can't. There's an order of this court saying that in the interim you should pay whatever, notwithstanding any issues involved, they should be paid.
I'll look into that, my lord. If the matter comes day after tomorrow.
Dr. M. Muzika today expresses his difficulty as much as he is not in receipt of any instructions pursuant to the order dated 12/10/2023. List this matter on this now. I'm looking at December. List the matter on 22nd November.
My 22nd of November, my lord.
Yes.
May I pray for 20th or 21st, my lord?
Yes.
20th or 21st, my lord?
20th of November.
21st.
20th. Okay, 21st November.
21st.
Alright. My 20th
For-
CAT, my lord, Contempt is on 20th.
The
Contempt is pending again. Contempt is pending again. They want
20th.
Contempt is pending.
Yes.
My lord. Alright.
Daily list, item number 1.
Avoid the bench.
Avoid chief bench. What is this?
Lordship, this was a PI regarding animal and cattle markets. And so, Lordship, on 19th, Lordship will see the order dated 19 October. We had filed a very detailed report. In spite of the fact the petition was not present.
No, but then the last line says that the
Last line says we have to file an adjourned.
more detailed report.
More detailed report.
What do you have to say?
You know, we just, I pray your lordship, the matter as per on the last order on paragraph 4 that the respondent hasn't complied yet the order, your honor.
What last order paragraph 4?
1990.
File a more detailed report.
Yes, on the, yes, your lordship.
No, whatever it is, they've already filed one report. That's already been, a copy has been given to you.
Very detailed report, Your Lordship. So in case
So what do you have to say on that report? You're not satisfied with that report? If you have anything to say, you can file an affidavit, and because it's a PIL.
Yes, your
It's not
lordship.
adversarial. So the thing is that you can file, if you have any suggestions, you can file the affidavit. They will file a more detailed report.
Absolutely.
Okay, your lordship.
Okay, meaning?
Your lordship, then we'll file a affidavit, your lordship, replying to it.
Yeah, counsel petitioner submits that prays that we are allowed to file an affidavit on the report filed by the state, which has been recorded in order dated 19/10/2023. Further, it is noted further that by the same order, the state was directed to file a more detailed report. This is matter for when? How much time will it take?
3 weeks, your lordship.
3 weeks. This matter to 3 weeks for further consideration. Yes.
Item number 2.
This is a unification challenging decisions of CRC and also the violation of the regulation. During the pendency of this discussion, further observation was made that no coercive action will be taken. And parties have been negotiating, a proposal has come from NTPC whereby the pending views of relating to power purchase agreement, those views will be paid as per NTPC. They have asked us to pay in 22 installments. Matter was referred to Cabinet. Cabinet has again asked the NTPC to.
What is the total amount outstanding?
It's roughly 700 crores, my lord. Roughly.
Around 600 to 700 crores. So So parties are still at the stage of
Is it a
negotiating.
fallout from the same matter which
Yes, madam.
which
It's-
this bench has taken?
Yes, madam. So CERC had passed an order, consequence of which is that they are supposed to pay us that amount, 700 odd crores. Instead of approaching Aptel, they've come before this honorable court. Honorable court, in view of the fact that state's interests is involved, without going into the merits, gave an opportunity for the parties to try and negotiate some sort of payment mechanism. Multiple meetings have been held.
No, but is there any positive
Yes, my lord.
steps?
Yes, my lord. There is
Then you will list it after some time. What's
Yes,
the point of
yes, my lord.
hearing the matter? Yes. Parties, legal counsel, the parties submit that the negotiations are still continuing, is yet to culminate in any final decision. They jointly pray the matter will be said after
4 weeks, my lord.
after 4 weeks to await any outcome. Yes. Accordingly, this is matter on so.
Item number 3.
Yes, Mr. Chanda. What is this?
We are the basic circular, whereby the benefit of the upgraded practical and extended by the government of India. These are not included in the petition.
My lord, some documents have been left out, my lord. While filing the writ petition, my lord, we have come against the order passed by the CAT, my lord.
Yes.
Central Administrative Tribunal. In the paperbook, some of the documents it appears have been missed out, my lord. So I am permitted to file an additional affidavit bringing on record those papers, my lord. 2 weeks time, my lord. I am free.
Mr. Chanda, do you wait? Let them file the additional documents which are necessary for adjudication.
And I may be permitted to bring on record some vital documents.
So you just wait. What we'll do is let them file first that let them file the additional affidavit and record other documents. Then you reply in totality to that. Why make it piecemeal? Yes, Dr. N. Mozikalana, DSG, assisted by so and so, submits that due to inadvertence, some documents which are vital in the instant matter have been left out. He prays that he may be allowed to bring the same record by additional affidavit. So the prayer is allowed. List after
2 weeks.
2 weeks.
After 4 days.
After 4 days. Mr. Chanda, you are very persuasive, but sorry. Yes. Sorry, I take some time because of medication. Yes, we staggered. Yes.
Any mention?
Lordship, I beg to mention item 44.
Like 44.
Lordship.
Ganga Sagar.
Lordship.
Yes.
It could come up after 2 weeks, Lordship.
Why?
Lordship, I'm not feeling well, Lordship.
You're looking very well.
Lordship.
Okay.
Obliged.
2 weeks and request from the council petitioner. Yes.
May I please, Your Lordship? Lordship, I beg to mention item 36, Your Lordship.
Yes.
Lordship, I beg Your Lordship to kindly let this matter come up after 3 weeks, Your Lordship.
Why? 3 weeks? We put it out for 2 weeks, okay.
Okay.
2 weeks is the request of the council petition, yes. Next. Yes.
High level.
May I please, Your Lordship, I beg to mention item number 40, Your Lordship. Let this matter be taken after 2 weeks, Your Lordship.
You've informed the other side.
Yes, Your Lordship.
What's the matter about?
Gaubura, Your Lordship.
Papa made like fun of me. 2 weeks, yes.
Similar prayer for item number 51, Your Lordship.
You've informed the other side. 41?
51, Your Lordship. 51.
$23, okay, 2 weeks. Yes.
Multiply, Your Lordship.
May I please, Your Lordship, I beg to mention item number 48, Lordship. That this matter must become after
Number?
2 weeks. 48, Lordship.
You've informed the other side?
Yes, Lordship.
No objection, 2 weeks, okay. Yes.
Yes, Lordship. May it please, my Lord, I beg to mention item number 39.
Yes.
Lordship, I pray for 2 weeks accommodation.
You're for the petitioner?
Yes, my Lord.
You informed the other side?
39.
Okay, 2 weeks, yes.
Obliged, my Lord.
Your Lordship, I beg to mention item number 37, Your Lordship, if this matter may be taken up after 2 weeks.
Aniket Raj?
Your Lordship.
What's the matter about? Service matter?
Your Lordship.
No urgency? 2 weeks, yeah.
Much obliged.
Yes.
I beg to mention item number 45, Malala already informed the counsel of the respondent. Lordship, I great leave of this honorable court to file an additional affidavit in this matter because some subsequent events have taken place after filing of the
45?
Yes, sir,
44 or 45?
45.
45.
What subsequent development?
Earlier when the petition was filed, only 8 candidates were shortlisted for remusteration. But now 11 candidates have been sent for training. So, that needs to be brought on record because...
Okay, MSP Agarwal, this matter, please submits that as there has been certain developments which have a bearing on the incident case, she may be allowed to bring those facts on record by way of affidavit. Stop. Not objected to by the learned DSG. Prayers allowed. This is a matter for 2 weeks, yes.
If it could be 3 weeks because the petitioner is posted in Manipur.
4 weeks, yes. Okay.
Yes. Lordship, I beg to mention item 43, Lordship.
4 weeks, okay. Yes.
The conducting council is out of station, Your Lordship.
Who's the conducting council?
P3, Your Lordship.
2 weeks, okay, yes.
Like Your Lordship.
May I please the Lordship? Lordship, with the consent of the other side, I beg to mention item number 41 and 42 of this release.
You are on whose behalf? On the petitioner side? Yes. Yes, Mr.
Mr. Pathak.
41, 42?
41, 42.
2 weeks, okay. Yes.
Supplementary list, item number 1.
Yes, Mr. Advocate General.
Yes, Lordship. My friend has filed the report.
You let him submit? Yes, Mr. Das.
My lord, may it please your lordship, my lord. My lord, the case in hand, why we have approached this honorable court in 2023, kindly see the backdrop of this particular case. My lord, in 2012, an expression of interest was invited by the government.
2012?
2012. For setting up 2 hydel projects. Upper Cray 1, stage 1, Upper Cray stage 2. And both this was, one is 15 megawatt and other is 10 megawatt. So this experiment 2012, we participated, we were the bidder. And in 2013, my lord,
yes,
letter of intent was issued by the state. And certain formalities has to be complied. Certain amount has to be paid. So in pursuance to that, in pursuance to a letter of intent, my lord, we agreed to it with the state government and we deposited a certain amount to the state government. And according to that, my lord, letter of award was issued in favor of us. Now, letter of award was issued and there are a lot of formalities which has to be done. We have to tie up with those contractors, subcontractors who are specialized in this subject. Accordingly, we appointed with 2 of the agreements with them and we started doing the groundwork. Thereafter in 2014, 9th of May 2014, my lord, preliminary agreement was executed with the government. Now, this preliminary execution we have to survey, investigate. Now, a DPR has to be submitted before the government. So, this is 9th of May 2014 and it stipulates there within 48 months we have to submit the DPR. 48
so
days.
12, then 2014.
2014, kindly see the dates, my lord.
4 years.
Yes.
After that means 14, that means 2.
Yes, that's
18.
So that's why first when I was given, when I was briefed, I thought that 2023, 2014, what is this 2012? But this takes lot of time. Now 2014, my lord, 9th of May 2014, an agreement was, preliminary agreement was executed with the government and 48 months we have to submit a DPR. Now very important, there are few clauses in that preliminary agreement with the government. There are few clauses which I will go later on, 4, 5, 8, 12. There are certain terms and conditions which has been laid down in those preliminary agreement. Now, one of 4 says feasibility report. Feasibility report has to be furnished to the government. Technical, techno-commercial also has to be submitted to the government. Now, there are certain terms and conditions where they can cancel it. So, those terms and conditions have been also narrated. So we overcome. There was nothing wrong on our part that it should be cancelled. So now this 2040, before 48 months. So before 48 months we submitted the DPR to the government. December 2015 we submitted the DPR to the government. Now thereafter we have not heard from the government. There were few letters with the government correspondence with us from 2015 till 2020. 9th of February 2020, government calls us that we want to meet you. So there was a minutes of meeting which we have annexed in this petition, my lord. 9th of February 2020, just starting before the COVID. They called us, they said, we want certain modification from you. So they said 1, 2, 3, 4. So we said we are ready. Accordingly, we have given some modification to them. 9th of February 2020 till 2021, somewhere 2021, August 2021, we have written a letter to them. What has happened? We want to know it. This is what we have given to you. There is no reply from the government. Now, thereafter, 2022, May 2000, April 2022, my lord, what they decide? The minister said, cabinet decision, some decision they have taken, and one of these our project they decide to unilaterally cancel it.
It's
On the
crafted.
ground that there is no financial viability. This was the ground. This is April 2022. Now, my lord, there is one clause. This is there is no opportunity was given before cancellation. This is one. Number two, immediately in the month of May 2022, we have written back to them. We said that this is what you just give a chance. What is there? You tell us, sit with us. This is May 2023, which is on record. No reply from their side. Nothing, no reply. Thereafter, my lord, in the month of September 2022, my lord, what they decided, my lord, they decided that to cancel this particular entire thing, and they said we have to sit, mutually you have to terminate this particular contract, mutually. But this was not done. We have also not come forward. They said some email was sent, we have not received any email from their side. This was happening in September 2022. We went to their office. We said that let us revive this. If you are on financial viability, technically you are said yes, it's right, only financial. So let us sit together because 80% of the job is complete. So only is a question of financial is involved. Now, when we wrote to them, my lord, they replied back and clarification is given by them, stating the amount which is given is not acceptable to us.
So what has happened as of today?
No, thereafter, why we have come up now, my lord?
Why you have come up?
Why have come? So we have now, cabinet has taken a decision. So what they said is not financially viable. They decided to now enter with some other new partnership with some parties.
Through open tender or just for?
I don't know. They said that they will some new partnership they want, and they will revive this project. They will revive this one. Now, there will be 4 points before your lordship. First point is that you want to revive it. So there is a question of saying that there is no financial viability. You want to revive this project. There may be 2 options. We don't want to go ahead. Financially is okay. We know where we stand it. Then our option is that we spend huge amount of money, 15 crores. Your lordship may not adjudicate this matter. We have to go before the civil court because there is no clause of arbitration. So we want to know what's the stand of the government, whether they want to revive it. Now suppose you want to revive it and you said financial it is not viable, but now the government says in a Twitter we said, in a Facebook the chief minister updated, said we want to revive and we want to enter with some partnership with somebody else. We don't know what partnership they want to enter. So we want to know, my lord.
Where the information do you receive that they are
my lord,
going to revive the project with someone else?
My lord will kindly see page 118. 116, kindly see, my lord. 116. 116. This is a determination, third paragraph, termination of 2 hydro power projects signed by so and so, namely so and so, and Upper Cree stage 1 and stage 2 project. We are concerned about Upper Cree stage 1 and stage 2. Okay. Now my lord will kindly see that 2 projects were in collaboration prior, but due to financial non-viability project and delay in implementation of projects by the companies. So there is no question of delay. I have submitted DPR, you have said, we also given you the correction. The government will immediately move for new partnership in a new format to implement the project. Now kindly see page 118. Kindly see 12th of September, 118, 12th of September down below. 12th of September. 2 projects were in cabinet approved termination, so the 2 projects were in collaborative private party. Financial non-viability projects and delay in implementation of project by the company, cabinet made the decision terminate the project. Government immediately moved for new partnership in a new format to implement the projects.
Okay.
So that's the reason why we are before this court. Now there are 2 things. My lord will ask the state, my lord, my learned friend Advocate General, whether they want to go ahead with or they want to give it a new partnership. If it is a new partnership, my lord, why they are not negotiating with me? Where huge amount of money has been spent. You go ahead with an NIT also, now a lot of money is involved. 70% of the work is complete, only implementation project final stages remain. You could have very well negotiated with me.
Now, at that time, award of the work to you, Mr. Das.
Yes.
Was it by open tender or was it by negotiation?
No, expression of interest.
By
expression
UI,
of expression of interest.
Yes, sir.
My lord, I will not ask normally. Today is a date when I am moving this matter. 2023 days. That's only the apprehension why I have come. I tried to settle with the government. But once we came to know, we got apprehensive and said that they may go ahead.
No, but is there any concrete, things that have happened after this announcement on Twitter or on Facebook?
That we are not aware. That's why, my lord. So there may be two things. One is that your lordship will issue a notice to it.
Because can we take cognizance of this fact, just something that's posted?
No, that's why I'm saying. No, that's why I'm saying that the AG has to come up and say before this court that yes, they are going ahead. Then your lordship, because yes, only on the basis of that.
Yes, sir. Let me rephrase the whole debate or the argument which my friend has said. Your lordship, the prayer in the repetition. There are so many arguments that we are going to cancel it, we are about to cancel it. They have completed 70% of the projects. All these facts are belied from their own pleading, my lord. There is nothing on that record, and facts will tell its own tale, my lord. Can you see the prayer? What is the prayer which they are asking? Before your lordship, page 23. Yes, your lordship.
Yes.
That this honorable court be pleased to issue a writ of so and so, which upon papers and proceeding which culminated into issuance of minutes of meeting of 20th April 2022, and after examining the legality, so what they are asking is quashing of minutes of meeting of 20th April 2022. I will place that minutes also. Commanding is withdraw the minutes of the meeting. What is being sought before your lordship to withdraw the minutes of the meeting, my lord. And, my lord,
what is this minutes in this? What is this paragraph?
Yes. 103, my lord.
Is the review of the work done by them since 2013. My lord, the lordship will bear this fact in mind that this project was started in 2013 and they have miserably failed to do anything in this. They are saying DPR everything. They have not placed those correspondences. My lord, I have gone through those correspondences. I can place, and so that this is a clear-cut case of abuse of process of law. Disputed question of facts are there, and if your lordship wants to see the minutes of the meeting, that minutes of the meeting is at page
103, my lord.
Cancel the MOA.
103.
101, my lord, is the minutes of the meeting. What they want, quashing of the minutes of the meeting. Whether it for quashing of the minutes of the meeting is maintainable, my lord. What they are annexing tweets, etc. They are all oral arguments here and there, and annex. But the real prayer is quash the minutes of the meeting. And what is the minutes of the meeting, my lord? The minutes of the meeting is review of the power projects which have been undertaken by state government time to time. And can you see it was conducted by none other than one of the highest political executive of the state, my lord. And they went through the project by project, my lord. And you will also will see at page 103.
Yes.
The MOA of these projects was signed on 9th May 2014 with Messrs. SM Energy Co. Guwahati. The appraisal report submitted by MEC projects are technically viable but financially not viable due to high cost. There are no representative from SM Energy Co. The Honorable cancel the MOA. Decided to cancel the MOA. My lord, kindly see the minutes which have taken place before that. My lord, kindly see page 94 now. 20 minutes.
Yes, 94.
Page 94. Honorable Minister in charge of our department who chaired the meeting, chairman observed that in view of the inordinate delay in filing the official report of upper so-and-so project 3, stage 1, has led to delay in accordance with TEC of 2 projects. It has become necessary to fix timeline for submission of replies by developer so-and-so. And raised on DPR and submission of appraisal report by so-and-so. Director Generation informed the meeting was held by MEPGCL so-and-so. My lord, kindly come to, I will not bother your lordship with the other paragraph 5 of the letter. CEO of SM Energy Co. placed the following proposal for consideration of the government. In view of the delay in receiving TEC for 2 projects which lead to escalation, the power project developer requested for waiver of additional 10% free power to government offered by developer during the bidding process over and above 12% free power to the government as per state power policy. to include the development of the approach road and other infrastructural facilities in the state budget, which will receive the financial burden on the developer to some extent. To waive off the charge for hydrometeorological data to be paid by developer for receipt of said data from MEPGs formulating DPR of two projects. To take into account additional power that will be generated by the downstream existing funds. So, and will not, you also will see the cost also is. Cost of this project is increased phenomenally. 8 rupees, that is also there. At page you also will see the cost which has been increased. They write that 8 rupees will be the minimum cost, my lord. Now, after all and the basis of all these is a preliminary agreement signed by party, my lord, page 49, my lord, can you see?
No, but has there been any form of formal cancellation of the letter of award?
My lord, that is therefore, my lord, if you also will see my letter, which were communication, before that you will also see the agreement, page 49.
Okay. Preliminary agreement.
Yes, sir. This is a preliminary agreement, and validity of the, and you will also will see this the validity of this preliminary agreement at page 50.
Yes.
Clause 4.
2 years time.
Within 2 years time, and you will also have noticed this agreement is signed in 14 on the 9th day of May on 14th, my lord. And within 2 years time, as the case may be, signing of the second party shall furnish to the government policy. Compendium giving details of hydrological and meteorological data. Typographical sheets prepared after conducting survey. A compendium of giving details of geological geophysical survey. A report of the power evaluation arrangement indices record. Feasibility report. In case second party is not able to furnish the above documents within stipulated time, first party will be at liberty to cancel the preliminary agreement. After affording opportunity to second party, no compensation whatsoever shall be payable by the first party.
You have a typed copy of this?
Yes, we have given typed copy, annexed.
Okay.
Typed copy have been annexed.
Yes, typed copy is also there.
Yes.
56 onwards.
Oh, thank God.
Yes, 56. Paragraph 4.
Yeah.
Yes,
yes.
58.
Right, 59.
And then you also will see clause 9. Clause 9, which is a type copy.
Milestones. Page 60.
Yes. Page 60. Page 60. Following milestones shall be achieved by second party, which consequential action will be taken by first party. Second party shall be required to submit monthly progress report to the power department. Nothing has been submitted. At the end of each quarter, second party shall be required to submit a quarterly report to the first party. First party will be at liberty to cancel the preliminary agreement that after affording due opportunity to second party in case first party is not progress made by the company. And then milestone is there, my lord. One, if you'll also will see upfront premium. Then conveyance of page 62, conveyance of feasibility, non-feasibility of the project, companion giving details of submission of detailed project report. So all these requirements are there, my lord, and if these requirements are not fulfilled, my lord, kindly see clause 12. This project has been hanging since last year. Now they are the validity, at page 64, the validity of preliminary agreement shall be up to
even then this looks like the realm of private law, absolutely. What manner was it?
Absolutely, this is, and then you also will see page 111. 111 in communication which we have made to the with reference to the above, I am directed to inform you the department has emailed to all private developers concerned, including your firm, to attend the meeting chaired by Honorable so and so. It is regretted you did not attend the review meeting, whereas other firms of so and so attended. The appraisal report, both in West Kathmandu district, submitted by MEPGCL on the last part of October 20, clearly stated the project was technically feasible, but tariff of 9.30 kilowatt hours and rupees 8.8 kilowatt respectively projects are not financially viable. And such decision was taken to discontinue the efforts. It is suggested further steps may be taken mutually by followed to the preliminary agreement is over within 48 48 months of DPR, my lord. These are all disputed questions of fact, my lord, and prayer is to quash the minutes and direct us to refund 15 crore rupees. That is the prayer, my lord. Therefore, in my humble submission, this writ petition is not maintainable. This is a dispute between contractor and the government, and the project has inordinately been delayed.
Only one roving question: whether steps have already been taken to restart this project with any other entities?
Your Lordship, the process will go on. I'm not saying as of today I have no instruction, but the process will go on, because if your Lordship has seen 111, where 111, because now as per them they are asking 9 rupees, my lord, and we have given them so far also what we have said. What is the response of this, my lord? They are saying the response is being examined and formal order will be passed in due course also.
Yeah, but I'll just give a reply. No, my learned friend has said a lot of things. Give me a reply. My learned friend is saying about 111. Man, I am asking myself where my learned friend can show from the preliminary agreement what is the ground of rejection. If the ground of rejection is on the financial viability, I have nothing to say. This is not a ground. He cannot point out before your lordship that ground of rejection can be on the basis. 1 second, AG, I didn't disturb you. I am just giving an answer to my learned friend. I am giving an answer.
Okay, wait, let him finish first. Okay, finish. What more do you have to say, Mr. Advocate General? What more do you have to say?
Yes, Your Lordship. Now, if Your Lordship will see later at page 111, what it says, Your Lord. We have written to them. It says that projects are technically but not viable. And decision was taken to continue the project. Therefore, it is the further step may be taken for closure. That is the notice which we have given to them. And preliminary agreement is already over, my lord. I have shown clause 12 at page 48 and page 60, my lord. So if that agreement is over, and what they are praying before your lordship is cancellation of minutes of the meeting. With a rate for cancellation of minutes of the meeting, a refund is maintainable, my lord. If the prayer is this, my lord, can they go beyond prayer? Whether the government has to take a step. For 10 years, they have not done anything. Project has not proceeded anything. Public interest is being harmed. We are taking steps in accordance with law.
Yeah, that's it.
Can I give an answer to it?
Yes.
Can I give an answer?
Yes, please.
My lord, my learned friend said 2014 that agreement is over. If that agreement was over 2014, my lord, recollect, within 48 months I have to submit a DBR. So 2015. What made the government to call us for minutes of meeting of 9/2/2020? They could have said very well, this is agreement, no longer it runs because we are not happy with the figure which you have given, feasibility report. So what we decide, no more calling, will terminate. Why they have not done? They have done in only 2022. Only you want to give to a third party. Now my termination is on what ground? Termination is on the ground of financially it is not viable. Let my learned AG show it that it can be on this ground, it can be terminated. This is what I am on before this honorable court, my lord. Agreement, what my learned said, that is over. If that is over, then why minutes of meeting of 9th of February 2020? You could not have 9th of February 2020.
Affidavit, then we'll take it up.
Yes, that's why I am saying, my lord, all these what my learned friend affidavit, that's why on the very beginning.
Then we will decide. Yes.
My lord, what we are saying.
But even then, Mr. Das, they are very. You have.
I will
to climb a very.
No,
high wall.
I will show. My lord, I also know, my lord. I'll show before your lordship. No, my learned friend is saying the writ is not maintainable. I will show the civil consequences of why it is not maintainable, my lord. My lord, termination has got a civil consequences. You cannot terminate.
Let your senior submit.
No. My lord,
he's eminently capable. I don't think he needs any assistance.
My lord, let a notice be issued, my lord. Notice be issued.
Let him file and we'll decide.
Yes, let you decide, my lord.
Because court also relatively serious doubts with regard to what relief can be obtained by the petition.
My lord,
two things. Mr. D. Das, senior counsel assisted by so and so, issue notice returnable in 3 weeks. Mr. Amit Kumar, you're appearing as Advocate General for one or
for all the respondents. For all the respondents.
For all the states. Mr.
For all the respondents.
A. Kumar, Learned Advocate General, with Sugar so is present on behalf of all the respondents. So no further notice called for. stop this matter after 3 weeks for
Can a date be
affidavit.
fixed if it's
Yes,
not
the date
inconvenient to
will
your
be
lordship?
list also. Yes, date be given.
And only the prayer for interim can be considered after returnable date, my lord. Suppose tomorrow, what I am saying, tomorrow they go ahead, I can definitely argue. Your lordship may reject it, that's a different thing. I am not saying.
Mr. Das, we will finish up the whole matter the next day.
No, what I am saying, my lord, let this matter on a returnable date. That is,
If any development takes place, you are at liberty to file a.
no, that's I know it. But I know it. But tomorrow, let me say.
Okay, right, okay, interim prayer, if any, shall be taken up consideration
Yes.
next date. Yes.
I am deeply obliged, my lord. I am deeply obliged.
Item number 2.
I am deeply obliged.
You didn't go for the World Cup?
Deeply obliged.
You didn't go for the World Cup? Yes.
World Cup is 23rd is final.
Believing you're going for that.
I'm deeply obliged, my lord.
Your friend's already there.
Yes, he is there. Already. He has to be there, my lord.
Right.
Only a date, my lord, which
Date will be
is
given.
convenient, my lord.
Actually, we are at the mercy of the court master regarding dates.
Yes, I am just requesting, my lord.
Your juniors are here, they will take it.
Yes, I'm deeply obliged.
Right.
The state has filed an affidavit, Maharaj. This is that matter concerning Maharaj, the appointments of assistant teachers.
B.Tech. Oh, sorry, B.Ed.
B.Ed.
Right. Yes. You don't require to file a jointer, correct?
Not necessarily. I've examined the affidavit. It's not necessary. Well, if I can take your lordships to the affidavit.
One second. Affidavit filed yesterday.
Filed yesterday, right? We've been served a copy yesterday.
Yes.
Well, if your lordships kindly have page 14, well, it's paragraph 15.
1-4.
Well, they say that it is submitted that the notification dated 28/6/2018 was held to be unconstitutional and contrary to the RTE Act. It is submitted that once a law is declared as unconstitutional or invalid, then the said declaration goes to the root of the matter and the said law notification is void ab initio. Now, what I had submitted before your lordships and what your lordships had seen on the last occasion was also, Milits. The Honorable Supreme Court, while dealing with the Rajasthan matter, was very circumspect in its intervention in the matter. While the writ petitions were allowed, setting aside the notification of 2018, it was categorically laid down, that any action of the state prior to the date on which it was set aside by any competent court, it would have been valid and had to be adhered to. Now, in our case, the advertisement itself had that particular clause of B.Ed with graduation.
Just sorry to interrupt you, Mr. Paul. But if I remember correctly, the Rajasthan judgment says that at that time the notification was still in force.
That's
when
what I'm
the whole
saying.
advertisement came out.
That's what I'm saying,
And it had not been set aside or interfered with in the entire process.
Lordships.
That's what happened there.
Lordships.
Right. Okay.
So that's exactly what I'm saying, Milits. That till the time it is set aside by a competent court of law, it is very much valid, Milits, and there cannot be any deviation from it. Now, therefore, the question that falls before us is, Milits, that once it is set aside at a subsequent date, by when the process is already started, people have acquired a certain right under that, Milits. I have applied. Whereas first, Milits, under that, I applied for MTET. I was granted an MTET certificate for life. With the MTET certificate, Milits, I apply for this particular post. Now, while this process is on, this rejection list comes in, under which, they say that now you're rejected, primarily because the judgment of the Supreme Court came. So, my humble submission was, even at that stage I had submitted before your lordships, that any setting aside of any notification by any court would be only prospective, it would not be retrospective unless your lordships clarify in the order that it would be set aside
Only
even
one
from the
point
date
that
on which it
disturbs
was
the
there.
court, you see, Mr. Paul, is that now this notification has been set aside as being unconstitutional, correct?
Lordships.
Whatever it is, okay, fine. That has been set aside to that extent that, okay, B.Ed they'll not be qualified to apply for these assistant teacher posts.
My lords.
Now, what would, by your definition, be, what is the stage of consideration? Will it be the whole thing, right, from the time the advertisement is issued to the time selection is done, or consideration, suppose midway the notification comes, that
consideration, my lords, in my humble submission,
consideration
cannot
of the candidatures.
Consideration, my lords, cannot be midway. Because if at all consideration, my lords, consideration is at the stage of interview.
Exactly, that is what this court is saying. So, if consideration comes stage interview, that means there will be debate.
My lords, it starts from the advertisement, culminates into the
appointments. Yes.
That entire process is consideration. That entire process is consideration, my lords. It cannot be. If I may draw an analogy, my lords. There was this advertisement, my lords. At that point of time, this was permitted. Now, if the state is saying, my lords, we are considering it now and therefore we've rejected it, that would not be permissible for them to say, primarily because of two reasons. If they take a position, my lords, that because of the judgment of the Honorable Supreme Court, now you are not permitted, then, my lords, they would have to withdraw that particular advertisement and issue a fresh advertisement. If they do that, my lords, I can do nothing about it because the position has changed. That they are not doing. What they're saying is the advertisement is the same. But midway somewhere, we are considering, because of the judgment of the Supreme Court, we are now taking away this right. You people are debarred and only these people will go through. Now, this was the same thing that was happening in Jharkhand, your lordships have seen. Chhattisgarh, my lords.
Chhattisgarh, yes.
So, Chhattisgarh also, my lords, because the Honorable Court had, the High Court had passed an order staying the entire recruitment process because these B.Ed people were permitted. The Honorable Supreme Court says that no, let the recruitment process go on. There would be limited right over these people to participate and it would be open for the court to decide from which date that order would come into effect. Whether it would be prospective or whether it would be given effect from a back date.
It's a very interesting point. It cuts both ways.
It cuts both ways. Yes. It cuts both ways. What ideally, my lords, in my humble submission, what ought to have been done, if this is the position of the state government, they ought to have withdrawn the advertisement. If they withdraw the advertisement, my lords, I stand nowhere. But they choose not to withdraw the advertisement. They choose to pass on, process the selection process as it is, and then they issue this rejection order midway through the selection. That, my lords, cannot be. It cannot be, my lords, that only on a certain criteria there would be a consideration by the state. Even coming on the point of consideration, my lords, whether I have B.Ed or whether I have DL.Ed, that separate consideration is nowhere written down in the advertisement. If it is not written down, you cannot one fine day decide that, okay, there will be an additional consideration of this point at this stage. The lordships are aware, my lords, the law as it is on service jurisprudence is once the game has begun, my lords, you cannot change the rules of the game midway. That is not open for the state. And what they're trying to say here in paragraph 15, my lords, the two judgments your lordships are aware, my lords, that what your lordships have held is of prospective overruling or prospective, my lords, declaration of law. Here it will not be a case of prospective overruling, but it will be a case of prospective declaration of law. Which is why the Honorable Supreme Court was very careful. While it saved the selection process, my lords, it struck down the particular notification.
Right, but some other considerations also regarding the qualifications and competency.
It did not say the selection process.
I'll hear you. I'll hear you, Mr. Arpijan. Yes.
Well, it's their affidavit says it's saved.
Yes. What do you show? Para 15.
Well, it's para 15. That is what they say, that it is submitted that once a law is declared as unconstitutional or invalid, then the said declaration goes to the very root of the matter, and the said law notification is void ab initio. Well, if it is declared void ab initio, it would have to come in the judgment that no right would have construed on or have accrued on anybody by virtue of that notification. That the Honorable Supreme Court does not say.
No, what about the Manipur judgment?
Well, Manipur also, if your lordships kindly see para 23, the highlighted portion at page 15. A declaration of unconstitutionality brought about by lack of legislative power as well as a declaration of unconstitutionality brought about by a reason of abridgment of fundamental rights goes to the root of the power itself, making the law void as its inception.
In its inception.
In its inception, that would be, my lords, where I did not even have the power to make that particular law. What we're dealing here is with a notification.
No, notification flows from an act.
The act has not been set aside, my lords. The act has never been under challenge. This recruitment is under that act. Your lordships are aware. If a law is brought in, my lords, and tomorrow the vires of that law is challenged before your lordships, and your lordships set aside the law, there is no question of prospective overruling. If a law goes, my lords, it will go from the date when it was enacted.
Right, and no rights will flow from there.
Correct. But that would be contrary to, my lords, the position when it is in vis-a-vis a notification or a government order. Because there is a law. Under that law, my lords, there is a power
now,
to issue an order.
What, if I understand correctly, what case you're trying to make out is that since the notification has gone, now whatever right you have vested with by virtue of attestament also, you cannot derive, anymore. You cannot derive any more profit from that.
My lords, which brings me to the second limb of my argument.
We cannot derive any profit
My lords, which brings me to the second limb of my argument.
Okay.
Then in that event, the advertisement has to be withdrawn. The doctrine of approbate and reprobate will come into play. In one breath, I say, my lords, I will proceed with that advertisement, which itself they say is illegal by virtue of it being struck down by the Honorable Supreme Court. And in the second breath, I say that the people who have applied under that advertisement will have no right. And I'm considering them now and I'm throwing them out. So it would not be open for the state to take that kind of a position.
Yes.
They would have to crystallize their stance on certain manner, my lords, saying that very well. Under 142, the Honorable Supreme Court has laid down a law. Therefore, my advertisement becomes bad in law, and therefore I will withdraw that advertisement.
Yes. Yes.
Now, para 16, my lords, they are trying to put in certain words. Your lordships will kindly see at page 17. Well, it is submitted that the said preposition of law is equally applicable to a notification, and even in case where a notification is declared unconstitutional, the same would be void ab initio. It is submitted that a notification is not on higher pedestal as compared to a statute passed by the legislature. Well, that is a preposition that is sought to be mooted before your lordships at this stage. Your lordships, let us go back to what the Honorable Supreme Court says in that judgment. Well, it's at page 86 if your lordships kindly have a look. There is a very important word that is there.
86 of?
The writ petition. When your lordships deliver judgments, well, there is a certain expression that is used which is of great consequence insofar as interpretation is concerned. Para 37, Millons.
Yes.
Consequently, these appeals are dismissed and the judgment dated 25/11/2021 of the Rajasthan High Court is upheld. The notification dated 28/6/2018 is hereby quashed and set aside. It is hereby. Hereby would literally mean, my lords, now.
Advertisement was dated?
Well, our advertisement was dated 14/6/2023, my lords.
14/6/23, and this order is dated
11/8/2023.
14/6/23, 11/8.
Last date was 31st. Last date for application was 31st August.
Very good.
That would be of no relevance insofar as this matter is concerned. So once the Honorable Supreme Court is saying, well, that it is hereby set aside, it would not lay on anybody's.
No. We'll see. No, don't worry. Yes.
So, my lords, what I'm submitting before your lordships is the Honorable Supreme Court says hereby set aside. Hereby meaning today it is set aside. So it is a case of prospective declaration of law.
Yeah.
Take out that relevant paragraph. That is that book. yesterday. That was the copy I marked yesterday.
Yes. Please continue.
So, my lords, once, in my humble submission, my lords, therefore, the question that arises is that whether I can participate in the proceedings at this stage. Till your lordships decide what would be the date, my lords, what your lordships would have to decide this issue. That whether it was declared void ab initio, so no rights would flow onto anybody, or whether, my lords, I would be able to participate because it was an action taken prior to a declaration of law by this Honorable Court, or by the Honorable Supreme Court. So either way, my lords.
No, the court appreciates the point that he's saying that the advertisement has not been withdrawn, it remains as it is. But the only thing that troubles this court is with regard to, again coming back to the consideration, what amount of consideration.
My lords, my humble submission my lords, consideration insofar as recruitment is concerned cannot be, my lords, one isolated incident. If it is a consideration in a regular, assuming, my lords, this situation did not arise. A consideration is, my lords, there would be a written examination. There would be a interview, and based on a cumulative decision, cumulative marks obtained by the applicant on both these two parameters would then be considered for the purposes of appointment. You cannot insert a third incidence, my lords, prior to me sitting for the interview, saying that, okay, since now you don't have this, we're going to oust you only on this point.
Yeah, I mean, it's common sense, but I think in this, because the circumstances are very peculiar, that's the only thing.
Well, which is why I humbly
once a notice is declared to be void, whether or not the consideration that is happening can proceed also.
My lords, in my humble submission, it cannot, because that will be inserting something into the advertisement which is not there. The only reason, my lords, which I say the Honorable Supreme Court interfered in the Chhattisgarh matter is this very consequence. Something which is not there in the advertisement.
We'll go back to judgment,
my lords, I'll take your lordships back to the Chhattisgarh. The only reason why your lordships, my lords, do not, your lordships interfered in the Chhattisgarh matter, allow these people to continue, is that there cannot be a midway consideration of something which is not there. Because when the advertisement came out, my lords, nobody could fathom that yes,
this thing is coming out.
At some point of time, this notification will be set aside.
Yes, okay.
And if I may go back to the advertisement, my lords. Now, if your lordships kindly have page 33, my lords, that would be relevant for the purposes of consideration. I can just quickly read it. Well, it's page 32. The advertisement starts. Para 3 qualifications I had already read, my lords. 4 is language proficiency, not important. 5 is also not important. 6 is also not important. At page 33, if your lordships kindly see submissions of applications.
It's only for Ampati, this one.
This is only for Ampati, my lords. Application should reach the office of the SDSEO Ampati. It should be Ampati, my lords, on or before 31st August 2023. Fulfilling all the basic criteria specifically above, incomplete applications will be summarily rejected. So there was no rejection on that day. It is not a case of summary rejection, my lords. Then if we come method of selections, candidates will be selected.
Was in November only.
Well, it's candidates.
Yes.
Candidates will be selected for appointment through board of interview constituted by the state government. Now your lordships will kindly see where is the consideration. Candidates will be selected for appointment through board of interview constituted by the state government. So that is the stage of consideration. And then if we come down, my lords, debarment. Candidates should make sure of their eligibility for the posts applied for, and that the declaration made by them in the application regarding the eligibility is correct in all respects. Any candidate furnishing incorrect information or making false declaration regarding her eligibility at any stage or suppressing any information is liable to be debarred from appearing in any of the examinations to be conducted in future, and summarily the candidature for this recruitment will be rejected. Using unfair means, well, it's not important, is vested with the duty of conducting recruitment and selection as per rules, duly maintaining utmost secrecy and confidentiality in the process, and any attempt not relevant, my lords. Impersonation not relevant.
That's not relevant.
Not relevant. So, my lords, the consideration as per the advertisement would be as per para 5. If at all, my lords, there was, I'm grateful my learned friend pointed out 31st of August was the cutoff date when I had to give my applications. If 31st of August, my lords, there was what they're talking about, and at that stage that occasion did not arise also. And it's not a case of summary rejection. It is a case where they say because of the judgment of the Supreme Court, now you do not have a qualification and therefore you're out. So that consideration, my lords, the state, it is not for the state to come and say that in between we suddenly started considering them, even while maintaining the advertisement.
Yes. Next point.
And I'll take your lordships to the judgment of the Supreme Court in the Chhattisgarh matter, my lords. Page 92, it starts, my lords, at page 93.
92 of your writ petition?
Of the writ petition, my lords.
A very interesting point, this one. Because what will be consideration? Yes, 92. 92.
My lords.
93, okay. Yes.
Your lordships, my lords, the background your lordships will recollect. There is a selection process on, my lords, where B.Ed people are being permitted to participate in the selection process. In that selection process, my lords, somebody goes to court, challenges that because of the Supreme Court order, B.Ed people are not eligible, and therefore the recruitment process is stayed. Against that interim order, my lords, the proceeding was taken up before the Honorable Supreme Court. In that context, my lords, in the meantime, taking into consideration the recruitment process which was in progress is now interrupted by the ad interim order dated 21/8/2023. And the aspect ultimately to be considered by the High Court is the regard to the manner in which the judgment in CA number so-and-so passed by this court is to be construed. At this stage, interrupting the recruitment process would not be justified. Therefore, to the said extent, we hereby stay the order dated so-and-so passed by the High Court and clarify that the recruitment process which is in progress prior to the date of the said interim order passed by the High Court shall continue, and appointments, if any made thereunder, will however remain subject to the result of the consideration to be made by the High Court in WPC number so-and-so. The selected candidate shall be informed of the same by the appointing authority concerned. In the meantime, notwithstanding the pendency of these petitions, the petitioners are hereby also implead themselves before the High Court in the writ petition, and if the High Court deems it fit to hear the parties and consideration of the not relevant for our purposes, well as they were given liberty to go and implead themselves before the High Court. So basically, well as the recruitment process which was initiated continues.
Right.
It is the same here. You allowed B.Ed. You have not withdrawn the advertisement. Now, if you've allowed B.Ed, you've not withdrawn the advertisement, my lords.
Yes.
Then I have to continue. Midway, you cannot throw me out.
Let him reply.
No, my lords, there is again another very interesting argument to this entire thing. Now, they've raised an alternative argument also. Now, I'll take your lordships to the alternative argument. And I don't know how the state will actually answer to that, my lords. If you just bear with me for a second, there's an alternative argument that is raised.
In the affidavit?
In the affidavit, my lords. What they say is, para 29. At page 27, para 29, my lords.
Because see, they'll try to maintain a case that the date of advertisement is not relevant for the purpose of this case and its consideration. It comes down to the consideration again. So if the state can satisfy this court, the consideration will mean at the
at any stage
at the end when after notification, if we even think the arguments prospective, then yes.
If I am not mistaken, my lords, in Chandrasekharan, your lordships have held that the process of recruitment, my lord, starts from the date of the advertisement, the date on which the select list
that you have to just give one or two authorities.
Because it says that midway, because that's where the principle comes in, my lords.
Exactly,
midway, you cannot change the rules of the game. Para 29 is very relevant, my lords, if I may just take your lordships at page 27.
Yes.
That it is alternatively submitted without prejudice to the other contentions that the advertisement was issued after NCT notification was declared unconstitutional by the Rajasthan High Court. It is submitted that the Honorable Rajasthan High Court declared the notification unconstitutional by the judgment on order dated 25/11/2021, passed in civil writ petition number so and so. The advertisement itself was issued on 14/6/2023, and therefore, even on the date of issuance of the advertisement, there existed no right in favor of the petitioners.
This is a fallacious argument.
Well, I just wanted to take it a step further. Assuming, Meloj, the Rajasthan High Court has actually struck down the notification of 2018, then it was not for the state to make that advertisement. That advertisement itself is flawed.
It is a fallacious argument. This is not whole.
So, as your lordships have rightly pointed out, Meloj, the issue for determination will be what is the stage of consideration.
I will hear you, of course. We'll hear you.
I'm sure your lordships will give you a very patient hearing.
It's a very interesting point, even for, so academically and otherwise.
Well, my only prayer would before your lordships would be, because when we were preparing this, our prayer is very carefully drafted. The limited prayer that the petitioners are coming up before your lordships is they may be permitted to continue with this selection process, depending on ultimately what your lordships will decide. That whether any right accrues on me or whether it doesn't accrue on me. And in terms of whatever has fallen in the Chhattisgarh judgment, same orders can be passed. That only limitedly these people will be permitted to participate. And they will be informed accordingly. And no, there will be no finality. It will be subject to the outcome of the writ petition before this Honorable Court. As to the date, what the Honorable Supreme Court says, it's construed by the High Court as to how that order of the Honorable Supreme Court is to be interpreted, whether it would be from the date of 2018 or whether it would be from 2023. Right. Subject to what I'll just place one judgment, that would be relevant for our purposes. This is 2009, 2001. Which portion is it? Oh, I'm sorry. This is 2001, 9 SCC, page 550. Relevant paragraph is paragraph 7. This is the case of Harsh Dhingra versus State of Haryana and others.
Para 7.
Para 7.
Yes.
Prospective declaration of law is a device innovated by this court to avoid reopening of settled issues and to prevent multiplicity of proceedings. It is also a device adopted to avoid uncertainty and avoidable litigation. By the very object of prospective declaration of law, it is deemed that all actions taken contrary to the declaration of law prior to the date of the declaration are validated. This is done in larger public interest. Therefore, the subordinate forums which are bound to apply law declared by this court are also bound to apply such dictum to cases which would arise in future. Since it is indisputable that a court can overrule a decision, there is no valid reason why it should not be restricted to a future and not to the past. Prospective overruling is not only part of constitutional policy, but also an extended facet of stare decisis and not judicial legislation. These principles are enunciated by the court of C.C. Jacob, and etc. etc. So, in my humble submission, the Honorable Supreme Court, while deciding that matter in 2023, was very conscious of this fact. It did not want to upset, what was already going on, and therefore, the expression hereby is used.
Yes. That's it.
Just this one. There are other judgments, I do not bother your lordships at this stage.
Yes. Yes, Mr. Applicant.
May it please your lordship. The issue which falls for lordship consideration is that whether the judgment of the Honorable Supreme Court in Rajasthan case declaring the notification is void of issue, and if it is a void and that declaration has been made by the Honorable Supreme Court, whether a state which is in the process of recruitment will be bound by the quash notification or will be bound by the recruitment. That your lordship kindly see the judgment of Rajasthan High Court. That will make because that is the fulcrum of the entire case they have. Your lordship kindly go see the judgment, my lord, at page 41 of the Rajasthan High Court judgment. The certain factual aspects also.
That is
throw some light. Page 48, my lord, of the writ petition. 41 of the writ petition, my lord. Paragraph 2, Your Lordship. A division bench judgment of Rajasthan High Court dated 25th November 21 is under challenge before this court. Apart from the appeals, there are 3 writ petitions as well as from before this court on the same issue. All the same, while dealing with these cases, if for facts we would be referring to civil appeal number 20. 3. What lies at the core of dispute before this court is the notification dated 28 June 2018 issued by National Council for Teacher Education, made in exercise of power under 23(1) of Right to Education Act 2019. Notification made B.Ed degree holders eligible for appointment to the post of primary school teacher. All the same, in spite of above notification, when Board of Secondary Education, State of Rajasthan issued a treatment on 11th January 21 for Rajasthan Teachers Eligibility Test, it excluded B.Ed degree holder from the right list of eligible candidates. This action of Rajasthan government was challenged before the High Court. Petitioner Sri Devesh Sharma has a B.Ed degree, and as per notification of 28 June 2018, he was eligible like many other similar candidates. Consequently, he filed his petition before Rajasthan High Court inter alia praying for treatment of 11th January 21 request, as it was in violation of notification of 28 June 28 issued by NCT. Apart from the above facts of the petitioner, there was another set of petitioners with the own grievance. They are the candidates who are diploma holders in elementary education, which was the only teaching qualification required for teachers at primary level, and who are aggrieved by the inclusion of B.Ed qualified candidates. They too filed a petition before the Rajasthan High Court challenging the legality of notification of 28 June 2018. The State of Rajasthan understandably supported the second batch of the petition before the High Court, as they would do before this court. Out of 3 petitions before us, 2 petition number so-and-so are challenging the notification dated 28 June 18 and consequent notification issued by Government of Bihar and UP, respectively calling for application from eligible candidates including B.Ed. Writ petition number 355 of 2022, again challenging the notification of 28 June, is against an interim order of Calcutta High Court which denied relief to petitioners who were seeking a stay of notification of 28 June 18. 6. Hence, the question of law to be answered in these cases is whether NCT was right in including B.Ed qualification as equivalent and essential qualification for appointment to the post of primary school teacher. Rajasthan High Court in the impugned judgment had quashed the notification of 28 June 2018, holding B.Ed candidate to be unqualified for the post of primary school teacher. So you also kindly mark that my friend is saying Rajasthan, this has been saved by the Honorable Supreme Court. This is B.Ed candidate is unqualified in Rajasthan, and this has not been saved by Honorable Supreme Court. So my friend is completely wrong on this submission. Now kindly see. Now submissions your lordship may skip, but one page your lordship may see at page 53, where the consideration started, paragraph 22. Paragraph
50? Page 53.
Page 53. Yes.
Paragraph 22.
Yes, consideration started consideration by elementary education in India is at 2 levels. A is at the level of primary, class 1 to 5, and B is the senior primary level, class 6 to 8. Presently, we are only concerned with primary level of education. Section 23 of the Act is extremely important, as it not only provides as to who shall determine the qualification of teachers in primary school, but also who can rely on this qualification and how long. Lordship may skip that part, my lord. Ultimately, what Supreme Court in this judgment holds, my lord, at page 56, your lordship will see paragraph 25. The academic authority, which is NCT, considered the appointment of trained and qualified teachers as an absolute necessary in primary school. It is for this reason that qualification which was prescribed for teacher in primary school was diploma in elementary education and not any other educational college, including B.Ed. And after discussing the powers of NCT on all these aspects, at page 60, last paragraph, just above paragraph 26,
Yes.
Moreover, middle of the page,
yes.
The inclusion of B.Ed candidates for primary classes in teeth of several decisions of this court, as this court has consistently held that diploma in elementary education and not BA is the proper qualification in primary schools. And then in paragraph 26, my lord, Honorable Supreme Court refers to its earlier judgment where BA has been held to be ineligible subject, ineligible qualification for teaching in primary. My lord, can you see paragraph 26? Dilip Kumar Ghosh is the first judgment discussed and referred by the Honorable Supreme Court. Then on next page, my lord, page 61, PM Latha and other versus State of Kerala is discussed. And then at 62, my lord, finding is there. Paragraph 20, BA is not a qualification for teachers at primary level of school. The pedagogical skills and training required from teachers at primary level is not expected from BA trained teachers. They are trained to teach classes at higher level, post-primary, secondary level. For primary level, class 1 to 5 of the training is DLED, or what is known as Diploma in Elementary Education. It is DLED training course which is designed and structured to impart skills in a teacher who is to teach primary level students. Now, after discussing this, at 64, third paragraph. In this background, the inclusion of BA candidates for primary level classes is beyond our comprehension. And after discussing, so therefore, what is being held, my lord, is that
we are reading that beyond our comprehension.
Is paragraph 60, paragraph 64, my lord, at middle of the page.
Page 64.
Yes, page 64,
right.
Middle of the page of Rajasthan judgment, my lord, of the Honorable Supreme Court. In this background,
yes,
the inclusion of BA candidates for primary level classes is beyond our comprehension. So, while examining the notification on merit power of NCT previous judgment, Honorable Supreme Court said that BA is not meant for teaching the primary school, the students of primary school from class 1 to class 5. So this is the finding of what my friend's case is, that they are having BA and therefore they are entitled to teach class students of
no, that's not the play at all. Anyway, continue. Yes.
No, if I take it, Milord, if I
see one thing, Mr. Advocate General, the basic difference between the case before us and this Rajasthan case is that before the notification came out, the B.Ed qualified candidates were already kept outside from the purview of selection. That's why they went before the court. Yes, and how does the judgment end? Yes. In this case, in your case, in spite of the judgment that come out, you issued an advertisement inviting B.Ed qualified candidates to apply. Simple as that. Then now with next stage, again we come to consideration. What do you mean by consideration? Whether consideration at the stage where you will be at liberty to say that we reject them because don't have B.Ed because we take reliance on the judgment of the Supreme Court in those two cases. That is, notification has been set aside. And so that their rejection will be justified.
Your Lordship, I will deal with this. Our notification was based on the notification of 2018, 11th June 2018.
Right.
My notification, my judgment was based
No, I was just interrupting you. Sorry, it's just because to show that on what footing this case stands, on what footing is the Rajasthan case. Rajasthan case is that they were not included initially from the beginning. So it would have been as per NCT norms only. As per the notification we struck off. Yes.
My submission before your Lordship is that this 11th June 2018 notification has been quashed.
What you're trying to show is that B.Ed is not relevant at all. It's not suitable.
B.Ed qualification is not a qualification for teaching primary school students.
Now, why don't you issue a corrigendum then after that?
Then why is the advertisement still there?
And now I will come to that. Now, second part, that is the second link.
Yes.
What I will deal with that aspect also. First on law, Milord. Now, kindly see the conclusion part. What my friend is saying that at this stage,
something wrong with camera, I think.
Therefore, you will also see that the conclusive part of the Supreme Court judgment in Rajasthan case. That Milord will find at page 85.
85.
Page 85. Middle of the page, having made the above determination.
Yes.
Before that, also, Your Lordship, the first paragraph, because the entire exercise is also procedurally flawed. The notification dated 28th June is not an independent decision of the NCT taken after but it is simply follows direction of central government, direction which fails to take into objective realities of the case. Having made the determination, we all the same are of the considered opinion that the state of Rajasthan was clearly in error in not calling for application from B.Ed qualified candidate for reason that till the time when such an advertisement was issued by Rajasthan government, B.Ed candidate was included as eligible candidate as per statutory notification of NCT, which was binding on Rajasthan government till it was declared illegal and unconstitutional by the court. Rajasthan court had rightly observed, we are of the opinion the state government could not have ignored the notification while inviting the application for REET. Even the state government was of the opinion such notification was unconstitutional or for any reason, the same had to be stayed or set aside by competent court before it could be ignored. What Rajasthan court has stated before, stated above, is the settled position of law. In a recent, will not kindly mark these lines, three judgment of this court in a state of Manipur versus Suraj Kumar Okara and others, this position that the statute which is made by competent legislature is valid till it is declared unconstitutional by court of law has been reiterated. So principles which have been reiterated in Manipur judgment law have been incorporated in this case also by. Consequently, appeals are dismissed and judgment dated 25th November 2001 of Rajasthan High Court is up. I have shown in paragraph 5 below, Rajasthan High Court, two facts were here. One, the state government issued notification excluding B.Ed candidate. Second first set of facts was that B.Ed candidate said that he could not have excluded. One more set of writ petition was filed by elementary qualified teachers saying that this notification of 2018 is bad in law, and the Rajasthan High Court heard both the matters and held one that without the notification being quashed by the High Court, the state government on its own could not have excluded because it goes beyond the power of the state government. But at the same time, Rajasthan High Court quashed the notification of 2018, holding that the B.Ed qualification is not the appropriate qualification. The matter when traveled to the Honorable Supreme Court said yes, the B.Ed is not the appropriate qualification, and that declaration was made on 11th August 2023. Now,
so okay, come down to our little case compared to these big cases.
Yes.
Now, what will the corrective measures should the state have taken in this aspect then?
Now the question, you also kindly see the advertisement.
Yes.
Now their prayer is, if I take it, Milord, their prayer is that you consider our case as B.Ed candidate. Their prayer is this, Milord. If their writ petition is allowed, the B.Ed candidate will be allowed to take part in the examination.
Right.
And they will be eligible. Yes. They will be eligible. My submission would be, Milord, my submission is that the Honorable High Court has quashed the Supreme Court has quashed the notification. After quashing the notification, Milord, they do not have a legal right to get themselves selected because their qualification is not a qualification in accordance with law. Their qualification is no qualification, Milord. So
okay, that is one point you have, that their qualification, who is it? Yes.
So their qualification is no qualification for teaching the students of primary school. So if they do not have the qualification, what right in law they have to ask for the relief, setting aside the treatment or setting aside the, or they have not setting aside, they have asked for inclusion in the select list. And my advertisement, Milord, is slightly different, Milord. Kindly see page 32. My advertisement, page 32, Milord. Kindly see my advertisement.
Yes.
Para 3, qualifications. Your Lordship, it has got 3 components. If your Lordship kindly read this notification with me for a moment, Milord. 32. Essence qualifications, para 3, Milord, it says qualification. Essential qualification for lower primary school teacher. This is class 12 class with 50% of for general candidate and 45% for ST/ST candidate with DLED or graduate with B.Ed as per NCT notification of 2010. I am talking about 2018, 2010 notification. Now, second qualification is, second compulsory is MT80 pass certificate, and third compulsory qualification even from B.Ed candidate is DEA pass certificate compulsory. This 3 is not vice versa. It's not only meant for DA candidate, it is for BA also. If you are BA also, but if you are having DA, you can participate. And this is compulsory, my lord, in my advertisement. My advertisement is based on 2010 notification, which provided DLED.
So your rejection is rejection based on the fact that they don't have a diploma?
Yes, your lordship, can you see my rejection order?
Or that they only B.Ed, or that their B.Ed passed?
No, they don't. If your lordship, can you see 34, page 34 rejection order, which is under challenge before your lordship? As per law, your lordship, as per letter number so and so 20, the following applicants, their candidates whose names are listed below for the post of assistant teacher in government lower primary school falling under so and so of Meghalaya are hereby rejected. Reason for rejection is mentioned on appropriate box. Any candidate of the given list may come to the office of undersigned for necessary clarification of claim before 16th onward, after which any claim of objection shall not be entertained. Now you also will see reason for rejection. Candidate, no D8, you also will find wherever D8 is. So all of them are not having, we are not saying that you are D8. We are saying that you do not have DLED, which is compulsory certificate, my lord. And you also will see in his candidate's case also, my lord. 88, my lord.
Yes.
37, serial 88, no DLED.
He's a petitioner.
Yes, he is a petitioner, my lord.
38.
All the petitioners are no petitioner in the eye of law.
He's which number on the list, Mr. Paul?
88, my lord.
88. Oh, 88.
First petitioner number 1 is at 88.
Okay. Vicky, okay.
No DLED. You can be DA candidate, but DELED is must. That is my advertisement. So my advertisement stands on completely different footing. Now coming back to the question of law, that's very important question of law my friend has raised. And my first submission is, Honorable Supreme Court has declared 2018 notification as void of emission. And for that, my lord, your lordship has raised very pertinent question. What is the date of consideration? Though I will succeed on, my submission is that the agreement is clear, my agreement is completely. I have prepared a short compilation on that issue, my lord. My friend will hand over the compilation. On the
give a copy to the other side also.
The other side also, my lord.
It's on consideration.
Yes, consideration, consideration. Your lordship, kindly see the last judgment first, page 77. 7th judgment, sorry, 7th judgment, page 77.
Of the compilation.
Of the compilation.
Yes.
Of the Honorable Supreme Court. Now, the school and intermediate facts are relevant. Schools and intermediate education institutions in the state of UP are governed by Uttar Pradesh Intermediate Education Act 1921 rules and regulations. Made thereunder. Procedure for selection and appointment of head of institution appears in minority institutions is provided in section 66F of the Act and regulation 17 of the regulation. While detailed procedure for selection is laid down in regulation 17 and subsection 3 of section 66F of the Act, mandate that no person selected as teacher shall be appointed unless the proposal for appointment is approved by district inspector of the district. In the present, two minority institutions initiated the process of selection of teachers and forwarded their proposal to DIUS for approval. Before requisite approval was granted, government amended regulation 17 prescribing a new procedure for selection. Consequently, DIUS returned the proposal for compliance with the new procedure. The institution challenged DIUS decision requiring the management to follow the new rules for filing the representative under transfer. By the order impugned before us, High Court held, once the management forwarded the name for approval of DIUS, selection process concludes and proposed candidate acquire a vested right to be appointed. High Court also referred to and relied upon the principle that vacancies that arise prior to amendment of rules have to be governed by rules that existed at the time such vacancy arose. State of UP in appeal before us, supporting the decision of the High Court. The respondent also argued before us that regulation contemplates deemed appointment, etc. My lord, and the facts are detailed, my lord, and issue is framed in paragraph 15 at page 81. whether the selection process, Your Lordship got page 81 paragraph, whether the selection process concluded and the candidates acquired a vested right to be appointed before the amendment of regulation, whether the act is then 3, whether the post of teachers could be filled as per rules and regulations that existed when vacancy arose and not as per the amended regulation. This is the most important issue, Lord, and kindly see the answer to this issue at page 85, paragraph 27, after paragraph 27. The
yes.
The board part of the judgment, whether the post of teachers could be filled as per rules and regulations that existed when vacancies arose, not as per amended regulations. Division bench as well as the single judge of the High Court accepted the submission of selected candidates that vacancies to the post of teachers could be filled only as per the rules and regulations that operated when vacancy arose, not as per regulations that came to be amended thereafter. We have already held that approval of DIS is mandatory and that the Act enjoins the appointment of teachers without such an approval. We have also held that legal regime concerning the appointment of teachers does not contemplate any concept of deemed appointment if DIS does not decide upon the proposal within 15 days under this reference to and reliance on the principle that rules that existed at the time when the vacancies arose will govern the appointment is misplaced. In any event, it is now settled principle of law that candidate has the right to be considered in the light of existing rules, my Lord kindly mark, which implies rules enforced as on the date of consideration, not on the date of advertisement, is not the date of consideration. The principle is affirmed by this court in Deepak Agarwal versus State of UP.
Now we just stop there. That is what it comes down to. This again.
Yes, Your Lordship.
What's the date of consideration?
Existing rule which implies on the date of consideration, my Lord, and date of consideration will be, my Lord, not on the date of advertisement. Date of consideration when I decide to appoint after interview, my Lord, and that stage has not come, my Lord. We are scrutinizing the application. After scrutiny, we have rejected the application, saying that you do not have compulsory DELED qualification. Consideration will be at the stage when interview is over and the matter is referred to the government for.
You require a little bit of more research here, I think, Mr. Paul, in this consideration aspect.
Let my learned friend finish, Willis. I think I've found the answer.
Yes. It is?
Your Lordship, it is now well a settled proposition of law that candidate has a right to be considered in the light of existing rules enforced on the date of consideration took place. There is no rule of universal or absolute application that vacancies are to be filled invariably by law existing on the date when the vacancies arise. Requirement of filling up old vacancies under the old rules is interlinked with the candidate having acquired a right to be considered for promotion. The right to be considered for promotion accrues on the date of consideration of the eligible candidate, unless of course applicable rule in Y.Y. Rangaiah case lays down any particular time frame within which selection is to be made. In the present case, consideration for promotion took place after the amendment came into operation, after judgment came into operation. Thus, it cannot be accepted that any accrued or vested right of applicant has been taken away by the amendment. Now, further judgment, my Lord, while affirming the above principle, in the subsequent case of Rajasthan Sports Council versus Kumar Dadichi, in which one of us, member Chanchu, as he did was, this court held, there is a merit in the submission which has been urged on behalf of the applicant that respondent has no vested right to promotion but only right to be considered in accordance with rules as they existed on the date when the promotion was being taken up. This principle has been reiterated by several decisions. In now 32 minutes, in recent decision in state of Himachal Pradesh with Rajkumar, after reviewing a number of decisions of the same subject, this court formulated the following principle. A review of the 15 cases that have been distinguished, this Rangaiah would demonstrate that this court has consistently been carving out exception to the broad proposition formulated in Rangaiah. The finding in these judgments that has a direct bearing on the proposition formulated in Rangaiah are as under. And your Lordship will see 3. 2. It is 2 million. It is now a settled proposition of law that the candidate has a right to be considered in the light of existed rule, which implies rule in force as on the date of consideration takes place. The right to be considered for promotion occurs on the date of consideration of eligible candidate. It's not that the state has not come below. The government is entitled to take consult policy decision, not to fill up the vacancies arising prior to amendment of rule. The employee does not acquire any vested right to being considered for promotion for a law. rules, decision. There is no obligation of the government to make appointment as per board rules in the event of restructuring of the candidate intended. The only requirement is that policy decision of the government must be fair and reasonable. Principle did not be applied merely because post was created is not obligatory to appoint. When there is no statutory duty passed upon the student to consider appointment of vacancy that is registered by. In view of the clear enunciation of law, we have no hesitation in rejecting the submission by the council to responding that vacancies that existed prior to the amendment of control must be governed by amendment. So principle of law, and then your lordship will see two judgments, recent judgment on this issue only, that what is the effect, state of Manipur Milord. Kindly see that judgment at paragraph 12, 22, 23 and 28 of Manipur judgment, which is, and it is part of compilation at page 12 Milord. And the relevant paragraph is at page 17. Page 17, paragraph 12.
Paragraph?
Paragraph
17,
23 and 28, my lord. Paragraph 22 is at page 17.
Yes. That's only quoted in the affidavit.
Yes, my lord. I have quoted this part. Where a statute is adjudged to be unconstitutional, it is as if it had never been. It had never been. Rights cannot be built up under it. Contracts which depends upon it for their consideration are void. It constitutes a protection to no one. No one has acted under it, and no one can be punished for having refused obedience to it before the decision was made. In Field J. Norton versus County, Selby County, observed that an unconstitutional act is not law. It confers no right. It imposes no duties, affords no protection. It creates no office. It is in legal contemplation as inoperative as though it had never been passed. An unconstitutional law to be either due to lack of legislative competence or violation of fundamental rights guaranteed under Part 3 of the Constitution of India is wide. In Behram Khurshid versus State of Bombay, it was held by Constitutional Bench by this court that law-making power state is restricted, my lord, and this principle is equally applicable. And then kindly see 28, my lord. And Roman 2 of 28, your lordship may kindly mark it. After declaration of the dispute, page 20, paragraph 28, Roman 2.
Yes.
After declaration of the statute, paragraph 28, small Roman 2. After declaration of the statute as unconstitutional by court of law, it is non-yes for all purposes. And this judgment, my lord, has been quoted by the Honorable Supreme Court in Rajasthan judgment before penultimate paragraph, paragraph 37. So for all purposes, my lord, the notification of 2018 is gone. And next judgment also, my lord, CBI versus R.R. Kishore at page 22, relevant paragraph is 95. At page 59, my lord.
Now, what about 3, then 28, Roman 3? In declaration of the law,
yes,
the doctrine of prospective overruling can be applied by this court to save past transactions under early decision superseded or statutes held unconstitutional. Now, this notification is set aside after application. Now, will not the court come to aid of these people to save, the action taken by the state where the rights had accrued rights at a point of time when they applied for the post, which is being taken away now, which is being taken away by them being rejected without advertisement being recalled. Yes, and whether we can rely upon the factual findings of Supreme Court regard to who's most suitable, a B.Ed or a diploma holder for elementary education, that this court will not go into, because we're not in a position also to discern as who's more qualified or what kind of qualification, So anyway,
the Honorable Supreme Court has held that
we understand. Yes. Once.
That is the finality on that issue.
So we're coming down to that now, that having a B.Ed, notwithstanding anything else, you're incompetent to be a primary school teacher.
Yes, sir. And that is the declaration of law by Honorable Supreme Court. That is my first argument, primary argument.
Right.
B.Ed is not a qualification.
Anything else? We've taken enough time, I think.
Just 2 minutes.
Yes.
Your Lordship will see this 90, this also. What my friend is arguing, 95, 96 million. 95, 96, Your Lordship may know because this, Your Lordship has had the matter final, page 59. Again, the Honorable Supreme Court has reinterpreted Manipur judgment aspect, my Lord.
Declaration on constitutionality. Even declaration on constitutionality. Which page? Which page?
Page 59.
Okay.
Yes, Your Lordship, after declaration of and 96 million. 96. From the above discussion, it is clear that once law is declared to be unconstitutional, being violative of so and so, then it would be held to be void of issue, stillborn, unenforceable, and non-effective of Article 32 of the Constitution and its interpretation by authority. Thus, the declaration made by Constitution bench of in the case of Subramaniam will have retrospective operations. So, my Lord, this was the issue whether it is a prospective and retrospective. And kindly see two provisions of the Constitution, my Lord, Article 141, Article 144, my Lord. Article 144, which is Article 144 of the Constitution, my Lord.
Yes. Yes, which judgment is this? This just now? This is
CBI versus R.R. Kishore. Start from page 22, my Lord.
interesting judgment. CBI, this is 2023.
Yeah, 2023 SSC Online SC 1146, my Lord.
Is a 5-judge bench.
Yes, 5 Constitution bench, my Lord.
Constitution bench, yes.
Issue was in that case whether judgment setting aside the provisions of PCI or Delhi Police, because requirement was for instituting FIR, you have to, against the Joint Secretary, you have to take prior permission. In Subramaniam case, that judgment set aside Section 6A of Delhi Police Act, my Lord. Then the issue arose before Constitution bench after declaration, what is going to be the effect of that declaration? And there in paragraph 95, 96, Honorable Supreme Court said once there is a declaration,
okay,
it will apply effectively. So this is the Constitution bench judgment. There is no confusion, very recent judgment. My Lord, can you see the Constitution, my Lord? Article 144, my Lord.
Yes.
All authorities, civil and judicial, in the territory of India shall act in aid of the Supreme Court. So we are bound to act as per the direction, because if it is this notification of 2018 is wide for all purposes, my Lord, my advertisement cannot override the judgment of the Honorable Supreme Court. And 141 also, my Lord.
Yes.
So 141 also. The law declared by the Supreme Court shall be binding on all courts within the territory of India. What my friend is arguing is contrary to Article 141 and Article 144.
Yes.
And last one, my Lord, what your Lordship will see, most of the cases, my Lord, what is happening is that this I have brought to your Lordship's notice that a resolution is authorization issue in paragraph 21.
Paragraph 21 of?
Page 21 of the repetition. 21 of the repetition.
What resolution?
This is the authorization letter issued by respondent petition number 2 and 3 in favor of petition number 1.
The point, but the points in law is that we take him to be him the sole petitioner.
In every case, this is the kind of authorization they are issuing, and this is not permissible in law.
As per CPC. Yes. What judgment?
That judgment is also you'll also will see page 1 of my
power of attorney. I don't think in this context of the matter we need to get into such tribal issues.
Your Lordship, because this is a practice which is happening in all cases, and that is why I have brought to the notice of the Lordship, because they are not following the law in filing repetitions. And
What kind of authorization should be there then, as per what order 1?
The requirement of law is, requirement of law is
Execution of a power of attorney.
is to be executed. Power of attorney is to be executed on valid stamp and duly attested in favor of petition number 1. And that is what law says. Here one page authorization letter is issued without knowing whether the person is authorizing has authorizing or not. There is no Bharat. These rules are required to be enforced. In all high courts, this process is power of attorney and rules are to be followed. That is what I want.
Just flag it, yes, sir. Fine. Yes.
This practice may not, the problem with this practice is, what if in other cases, the problem with the practice may not be 21 authorization letter, whether the
No, only thing the authorization is not on proper form. Right.
Assuming, my lords, petitioner number 2 and 3 go away, then also the issue of petitioner number 1 remains.
Even if we disregard, these other people to authorize the petitioner, then the point and issues remain the same.
The Advocate General of the state would have been raising these issues.
No, he's doing it in terms of the power right.
Election petition is different from a writ petition.
Right. Okay.
Well, I'll very quickly respond to whatever my learned friend has argued before your lordships. We've already
all other matters are waiting. Yes.
Well, I'll take 5 minutes. And on the issue, that had fallen from your lordships, we've got a judgment that squarely sits on that issue.
Let's see.
Court Master, if you kindly just place this. Well, this is 1993 SCC page 157.
Hearing in this matter.
1993 SCC.
1993
SCC page 157. N.T. Devin Katti versus Karnataka Public Service Commission. Relevant paragraph is paragraph 11. The blue flag, Court Master. I have marked paragraph 11 for your lordship.
Right, yes.
There is yet another aspect on the question whether advertisement is issued inviting applications for direct recruitment to a category of posts, and the advertisement expressly states that the selection shall be made in accordance with the existing rules or government orders, and if it further indicates the extent of reservation in favor of various categories. The selection of candidates in such a case must be made in accordance with the then existing rules and government orders. Candidates who apply and undergo written or viva voice test acquire vested right for being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intention. Generally, a candidate has right to be considered in accordance with the terms and conditions set out in the advertisement, as his right crystallizes on the date of publication of advertisement. However, he has no absolute right in the matter. If the recruitment rules are amended retrospectively during the pendency of selection, in the event of selection must be held in accordance with the amended rules. Whether the rules have retrospective effect or not primarily depends upon language of the rules and its construction to ascertain the legislative intent. The legislative intent is ascertained either by express provision or by necessary implication. If the amended rules are not retrospective in nature and the selection must be regulated in accordance with the rules and orders which are in force on the date of advertisement, determination of the question largely depends on the facts of each case having regard to the terms and conditions set out in the advertisement and the relevant rules and orders. Now, this part is important, my lords. Lest there be any confusion, lest there be any confusion, we would like to make it clear that a candidate on making an application for a post pursuant to an advertisement does not acquire any vested right of selection. But if he is eligible or otherwise qualified in accordance with the relevant rules and terms contained in the advertisement, he does acquire a vested right of being considered for selection in accordance with the rules as they existed on the date of advertisement. He cannot be deprived of that limited right of the advertisement on the amendment of rules during pendency of the selection unless the amended rules are retrospective in nature.
Okay.
So that is my limited case before your lordships.
The reserve for judgment.
This has been considered, this judgment has been considered when overruling all these propositions, Lord. And as of today,
it is
overruled in
my favor.
overruled. This is overruled.
It's
overruled.
And Lordship kindly see Rangaiya judgment which I have referred. The judgment, the principles have been discussed in detail in Lord State of UP versus Rachana Hills, paragraph 28.
Where?
77.
77.
I have not seen this, but if it is overruled, then I
77, 88. Okay.
Your Lordship will see page 86.
87.
86
at paragraph 32. in a recent decision, the state of Himachal Pradesh Mr. Raj Kumar, after reviewing a number of decisions on the same subject, this court formulated the following principle. A review of 15 cases that have distinguished Rangaiya would demonstrate that this court has been consistently carving out exceptions to the broad provision formulated in Rangaiya. Finding of these judgments that have a direct bearing in the provision formulated in Rangaiya are as under. 2. It is now a settled provision of law that candidate has the right to be considered in the light of the existing rules, which implies the rule in force as on date of constitution takes place, right to be considered for promotion occurs on the date of constitution for election of candidates. 3. Government is entitled to its policy.
Now, where's that state? Where's the state of Himachal versus?
Well, it's not overruled. In 2023, the Honorable Supreme Court has reiterated this.
The issue is, this judgment.
We can't say it has been overruled.
No. You're saying that it's diluted the principle. That's what you mean to say.
After 15 review of 15 judgment, Milord.
No, is this part of the review?
Well, it's in 2023.
Take out a judgment.
Well, this is decided on.
18 is what is the citation of this?
Well, it's what I've cited before your lordships is. I'll just give you lordships. This is 1993 SCC page 157.
Himachal.
No. This is, my lords, Devan Katti versus Karnataka Public Service Commission, and this has been reiterated. This position has been reiterated by the Supreme Court in 2023. My lords, February 20, 2023. I'm placing that judgment also. It's not overruled. We cannot make these callous statements in court.
We're confusing the court.
Your lordships will kindly see this judgment is reiterated on 20th February 2023. The Honorable Supreme Court is again relying on that same judgment.
Which para?
Well, I'll just mark that portion. I'll just give it. It's here. I have it here. It is at para 23. I think running page would be. Para 23, my lords. Discussion, your lordships will see. It starts from para 22. Discussion starts.
Yes.
Then para 23, another unique feature of the present case's selection. 24, my lords, it is true that a candidate may not have a vested right to the post. However, it cannot be confused with a right to be considered in accordance with law. A law which enables a candidate to get a post cannot be changed to facilitate another group of persons, since the candidate acquires a vested right to be considered in accordance with the law, as held by this court and so and so. Para 11 is again reproduced, my lords.
Okay.
This is in 2023.
In accordance with law, law is there that the B.Ed is not a qualification.
This is again another issue.
Quite a vexed question anyway. I've heard reserve judgment.
Good night. It's on the doctrine of appropriate, reprobate. There's only one judgment. Your lordships are aware. I'll just give the citation. 2013 5 SCC 470.
2013
5 SCC page 470. This is Rajasthan State Industrial Development and Investment Corporation and another versus Diamond Gem.
What is the relevant paragraph?
The paragraph is paragraph 14, where they deal with the doctrine of approbate and reprobate.
Okay. I hope it covers, because the entire notes arguments are coming 1.5 page of my notes. Yes.
I can only submit, that's where the difficulty of the honorable judges start, and the lawyers can go home.
Yes.
I'll be obliged.
Daily list, item number 1.
Well, perhaps this matter can be taken on another date. It will take some time, my lord.
When will Miss Goyal come personally to Shillong?
This is really not an.
In fact, my lord, I was due to travel. Somehow I had an intuition that the other side, although has not informed us, may take time.
I'm not taking time.
In case.
Not really time, my lord.
So when will you come? We'll have it in the date when you're coming, yes.
Whenever, maybe on 20th, 20th.
21st.
If my friend is ready.
21st, is it?
No, I think.
20th, I'm traveling to Shillong, so if it is on 20th, it will be very convenient.
21st? 21st.
No, then let it be sometime in December.
I think that will be better.
Okay, December, whatever. That we've given it the entire up to you, your choice. Yes, this is and on the request of the party. This is matter on December so and so.
Madam, the interim order has. Madam, I am ready for hearing today. I am not asking for adjournment, but anyway, since he.
Interim order shall continue until next day.
No, this is not
The
really an
interim order has to
adversarial,
continue, my
because
lord.
this case will have an implication on many other matters which are pending.
The interim order has to continue, my
Yes,
lord.
interim order shall continue to the next date. Yes.
And I'm grateful, my lord.
Item number 3.
Please. Lordship.
Yes.
In this matter, Lordship, while filing the suit, Lordship, along with the plain, some documents has been annexed. So, having gone through the documents, Lordship, certain documents has come up into my notice, which I would like to place it before your Lordship.
This is still a revision. What affidavit will you file now?
No, not affidavit. Some certain documents, Lordship, which your Lordship may go through it.
Is he privy to them?
No, I'm not. I'm not sure what documents are these, my lord.
Annexure.
So what documents? What do they say, Mr.
Your Lordship, this is one document, Lordship. In this case, Lordship, particularly relating to this, my plaintiff, respondent herein, your Lordship has once appeared. And that against.
Against whom? Against the Hindu Mission?
Yes, Lordship. And
in this matter,
not this matter, but the suit property is more or less same.
May have been some other matter and against them, my lord. So
and that has been relied in para 5-6 all also. And
yes, Mr. Upadhyay has informed this court. Which order is that date?
Lordship, that is a compromise decree. Annexure 4.
No. Date of the.
Date I will, Lordship. 3/6/2002.
Mr. Upadhyay has informed the court that that in the decree dated
3/6/2002.
Yes, this court concern was one of the counsels. Accordingly, this is matter before any other bench without me. So.
Item number 4.
Don't remember.
Lordship, yes.
That
is relating to another.
That property actually is not the suit property, it is the adjoining property.
But concerning the same property of the
Daniel's compromise will never argue it, so you won't remember. Yes. Thank you anyway. And it's your duty. Mr. Jarwa, affidavit file.
Not yet used.
Number 5.
We have filed our objection, Lordship.
What about your affidavit?
I've just received the brief just last night, my lord. So I'm praying for.
But Mr. Jarwa appeared on your behalf.
My lord, that time we have not yet to receive the brief at that point of time, my lord. Just because the matter was listed, that's why we had appeared. Only yes.
Number 6. Number. What about 1, 2, 3?
Same will be filing.
You'll be filing.
Will be.
So only number 4 will file.
My lord.
Mr. L. Kiriam, Learned Counsel Zone before submits that in spite of time being taken on 1st November, he has just received the writ petition for the file and please not allowed further 2 weeks time to file affidavit. Stop. It is noted that you want to take the point of maintainability first. This is the matter after 2 weeks admission hearing, especially the point of maintainability. You become prepared.
Okay.
Item number 5.
Order sheet been filed?
Yes, Your Lordship.
Yes.
Lordship, let the matter be taken up for hearing on the next date, Your Lordship.
For hearing? What's there to hear on this matter? Where's the order sheet? Why did you want to file the order sheet? You're not prepared for the matter. Who's leading you in this case, Mr. Gautam?
Mr. Gautam, my lordship.
Office note, counsel for the submits that and after it's been filed, including the order sheets. Where's that?
I have received it.
Learned counsel for submits that and after it's been filed on behalf of the petitioner, bring on record the order sheets passed by the trial court connection with special POCSO case number 45,015. Stop and representation dated 4/5/2022. Stop. Further praise that the matter be listed for.
Let it come for order, Your Lordship, because the trial has been stayed, Your Lordship. Apply, Your Lordship.
Item number 6.
This matter, my lord, we have filed an adjournment today again, my lord, seeking some more time.
Why? You're not interested in pursuing the matter anymore?
Not exactly, my lord. We have not been able to make contact
You
with
can't
this
go on
gentleman
like
who's
this.
from Garo Hills, my lord. I'm praying for a week's time, my lord. We are.
You want to withdraw, then withdraw it, pause.
We have filed. The objection is already ready, my lord. He only needs to come for signing.
You said you don't want to proceed with the case.
No, not this case, my lord. The other case has already been withdrawn.
Oh yes, okay, Mr.
We'll file this.
You want to see the adjourned petition? Yes.
So let it come for hearing on the next day if
Yes,
they are
the
not
adjourned
interested.
petition,
Lordship.
So matter stands adjourned to next date for the grounds stated therein. List on so and so.
Hello.
Will take 2 weeks, sir. Yes, after 2 weeks or so.
7.
7, we were required to file the list of witnesses, my lord. We are filing it today, my lord.
List of witnesses?
Yes, in the course of the day, my lord.
Mr. We will record. You file it first, then we'll pass orders. They'll bring a file to the chamber. Yes.
8.
This is Your Lordship. Lordship, this matter, the order has been complied with.
Correct.
We have not received any instruction, Your
Let's see
Lordship.
what they said. What is the order violated? We won't hold his contempt, and there's no point in. Oh, she's the teacher.
Lordship, kindly come to the order, letter dated 30 November 2023. That is the letter issued by the director to the district school education officer, and Lordship will kindly find the order of appointment in the next page.
Yes. You have to give it.
Your Lordship,
The EAG has
Your
produced 2 communications dated 13 November 2023 and an order of appointment dated 14 November 2023. Review the matter. Nothing remains for consideration and the contempt is closed. Copies of the communications are kept on board. Are taken on board and made part of the.
Your Lordship, if you allow us to obtain
No
instruction
instructions.
Monday on Your Lordship.
Apply, Your Lordship.
Yes. We won't keep this thing done. There's the order of appointment. You can file fresh petition if you haven't regularized it.
9.
In this matter,
Lordship, pleadings are complete, my lord.
This party submit is complete this matter for hearing in the usual course and so on. So.
Much obliged, Lordship.
10.
Please, my lord. All the pleadings are complete, my lord. The matter will be posted for hearing on the next day.
You haven't filed a joinder?
Yeah, file, my lord. Pleadings complete.
Yes, party submit please complete this matter for hearing in the usual course and so on and so on.
2 weeks, my lord. Much obliged.
11.
Please, Your Lordship, I pray for 1 week time to file an affidavit.
Has been for the 2 weeks time granted to state respondents to file an affidavit.
Well,
Actually, I will be 2 weeks on week. I'm not coming on affidavit. Yes.
Lordship, I pray for further 3 weeks time as the petitioner is unable to come and sign the rejoinder petition.
How many times you prayed?
With this second time.
Third time?
Second.
Okay. 2 weeks is rejoinder.
13.
Lordship, I'm appearing for the respondent numbers 1, 2 and 3 in this matter for the state. I have already filed my affidavit.
Number 4, why not? You're not filing affidavit?
I'll file it, Lordship, in the process. I need only two weeks time,
Process was
Lordship.
meant today.
I'll file it tomorrow, Lordship.
Okay, Mr. S.A. Sheikh, response allowed for the 1 week's time to file affidavit. Rejoinder? Just 2 weeks, not necessary.
Not necessary because I have.
So let him file first.
14.
Item 14 to 23 are those judicial matter, NCRC matters. The Lordship has partly heard it and it will take some time. This item 14 to 23.
No, we'll hear it in. Today is the 15th, 16th.
Yes, sir.
22nd.
I'm not in a hurry, my lord. I believe the other respondent, they have some stay against them. So,
who?
Mr. Paul.
22nd. 22nd, we'll have 22nd. Mr. Paul, 22nd. There's a stay against you. Then I know.
22nd, Malad's next coming week, I'll have a little difficulty. I would not like to seek an adjournment, Malad's. Your Lordships could kindly have it week after that, Malad's. 28, 29th, any day.
28, 29, you see that the same problem we are having is that, like, I'm the traveling judge of this High Court. So for all these conferences, I have to attend. So there's a problem. There's an international conference on 27, 28, which I have to attend. So I'll get back by 30th.
But could we have it on the first week of December then, Malad?
First week of December, yes.
That will come up again, Malad. I'll seek an adjournment. It's not proper.
24.
Yes, Mr. Shulai.
May it please your Lordship. Lordship, there is a representation. So
no, if you suppose to file affidavit.
Yes, Lordship, yes. Lordship, yes. But there is a representation if description, if the department can be.
Only difficulty is, my lord, the representation was made prior to the retirement. In sometime October, November 2022. I retired in February 2023. Thereafter, I filed this writ petition with two prayers, my lord, notional promotion with effect from 2018 and a pay benefits, my lord, of level 21.
Which department is this?
This is
This
DMR,
is mining, your Lordship.
This is the post of director, mineral resources, my lord.
Now, what representation is the AEG talking about?
Yes, my lord.
Is it next year?
It's the next, my lord. Page 44, my lord.
44, your Lordship, yes.
This is, oh sorry, my lord. The latest one.
Oh no, 55, your Lordship. Yes. At page 55, your Lordship.
55 is October 2022, prior to my retirement. So if they consider my my representation along with the two prayers that I have for notional promotion and pay benefits of level 21, then I have no objections if this matter can be disposed of, if they are willing to consider.
This is still pending, your Lordship, pending consideration.
When did he retire?
March 2023.
So he made this in 19th October. March 23 retired.
Lordship, we can approach with a fresh representation.
I think
also.
better you want to file a composite one. And we'll give them a time for it to dispose of the
Lordship,
representation.
Well, it will be slightly difficult. It is better, my lord, if they consider my the representation prior to my retirement, along with the two prayers in my writ petition. Because my case is, my lord, that in 2018 when the DPC sat, it was kept in abeyance for the post of director, saying that the service rules are pending approval. 2018, my lord. while the other post on this, the same DPC has granted promotion for the remaining post in the department, except for this post. Now, over the years, my lord, I was under the impression that yes, the department is seriously.
Then you won't give the requisition. You file the affidavit. How much time?
Let it be 2 weeks time, Your Lordship.
Yes, 2 weeks time has paid. It's matter because it's twofold. It's indeed out
Because
of
it is
court.
only after my retirement that I receive a letter.
Understood. Yes.
25?
For 2 weeks time.
25?
25, 26, Your Lordship, we have the instruction, so kindly allow us 2 weeks time, Your Lordship.
My lord, in this matter also, my lord, the vacancies occurred in, one vacancy occurred in
Same department?
February. No, this is Urban Affairs
this is
Department,
Urban Affairs, Your Lordship.
Joint Director post, my lord. Vacancy occurred in April 2022, one post, and one in March 2023. There was a DPC held in June, my lord, we were not considered. During the pendency of this matter, my lord, this matter was filed in August. They have obtained, my lord, time 3 times over, my lord. In the meantime, my lord, we have received a notice that another DPC sat on 30th of October. Still, my lord, nothing.
We'll file the affidavit, Your Lordship. We have the instruction, we'll file
And
it.
one of the petitioners is retiring soon, my lord. Hardly 1 year of service left, my lord.
When will you file it, Mr. Shulai? 1 week?
Let it be 2 weeks, Your Lordship.
2 weeks of final opportunity is granted to the state for
We'll file
affidavit.
it, certainly.
Both items.
Both items, Your Lordship.
27?
Apply, Your Lordship.
Lordship, I pray for further 2 weeks time, Lordship, to file my counter, Lordship.
In 2 weeks.
28?
Yes.
This is the very brief matter, my lord, which my learned friend has also argued, and it is for final hearing, my lord. It will take some time. 22nd, your lordship, may I have your permission?
22nd. You are here only? Yes, sir. This is matter on 22 of November as prayed. Interim orders continue for the next date. Which matters is or
That license was granted till 25th, cut short. Obligement.
29?
You're still running the way bridge now. You're still running it, so you have no urgency. Yes.
Yes. Can you allow me to withdraw this petition, Your Lordship?
Why?
But on the last occasion,
Oh, yes,
indicated.
yes. That same, that gratuity matter.
Complied.
Yes, Mr. Dinota submits that praise is allowed to withdraw the incident petition.
With liberty, Your Lordship. With liberty to file afresh.
With liberty to file afresh, if so advised, yes. Praise granted with liberty as praise.
30?
Matter, petition is closed on withdrawal with liberty as praise.
Worships. The other side would
1 to
file
6
after.
and 8.
My lord, I appear for
And
the
9?
three respondents, my lord. 1 to 6, 8 to 9, my lord.
Why?
My lord, I'm praying for time, my lord. This is the second time I'm making a prayer.
Who are other respondents? They've been served.
My lord, 7, my lord. 7 is
Accountant General.
accounted
Karma
aging, my
Plan.
lord. My lord, this with regard to pensionary benefits. Pensions have
Further 2 weeks time. 2 weeks time.
The non-payment of increments.
Yes?
This was a matter concerning the non-payment of increments alone.
2 weeks. Yes.
Right. 31?
My lord, in this matter, we have received the affidavit of objection filed by the other side yesterday, late afternoon, my lord. My lord, I'll require some time, my lord, to my lord, obtain instructions, and if so advised, my lord, we'll file our rejoinder. Certain objections have been raised. I'll just require a week's time, my lord.
Why should you do the transposition of the
Yes,
parties?
my lord. My lord. A week's time.
Mr. P. Nombri, the counsel for the praise for week's time to file objection to the affidavit filed by the respondent corporation, respondent company. Praise allowed this after 1 week.
Deeply.
Yeah.
32?
May I please, Your Lordship?
5 and 6, you sent individual notice?
Yes, Lordship. Waiting for
Not
the
yet
service.
received. Yes. Officer indicates that the service on respondent 5 and 6 yet to be completed. What will you do? You'll obtain status?
Yes.
Yes, sir. Petitioner counsel submit that. Please, you will have to obtain the status of service. What about the affidavit?
Lordship, we have the instruction, we'll file the affidavit, Your Lordship.
Yes, sir. Stop. July on behalf of 124. Please allowed further 2 weeks' time to file affidavit. Yes,
Apply, Your
after for service report or for report on service and for affidavit of respondents 124.
33.
This is after on some more.
Your Lordship, in this case, respondent has responded, Your Lordship, to my representation. So I will withdraw this petition, Your Lordship.
Mr. Nyota submits that as the respondents have responded to the representation made by petitioner, he may be allowed to withdraw this petition at this stage. Yes. Accordingly, petition stands closed for withdrawal. No liberty.
No.
Apply, Your Lordship.
And accordingly, it's closed.
34.
Accordingly, the petition is on withdrawal, is closed and disposed of.
Milord, item 34 and 35, Milord, connected. Milord, I'll require some more time, Milord, to file my affidavit. This is that matter, Milord, wherein, in terms of Jagjit Singh, we are giving the minimum pay, but their claim is that previously under the fourth pay, we were supposed to get all the other benefits. So I require more time on that, Milord.
What about state not filing anything?
Lordship, you rely on the affidavit.
Yes, Mr. Philemon Nongri, on behalf of responsible for previous forms, Lord, for further 2 weeks' time.
Deeply. 35 is connected, Milord.
Hearing 38.
Yes.
Lordship, I'm praying for some time in this matter.
Why? Mr. Datta, when you have it after 1 week?
Lordship, after
12th of December?
12 is a holiday, Your Lordship.
12th is a holiday. Yes, 11th. 11th. This is a matter of 11th.
Highly obliged.
46.
This matter 11 December. Yes, Mr. Sen.
Employees Provident Fund, which was settled at the intervention of the court, but again they have reopened, and Lordship has granted me a stay. So I don't know, it'll take some time.
You take a date. She's unavailable most of the times. So, what date?
Lordship, actually, it's apart from 5 and 7 December.
Well, whatever convenient to this.
5th, yes.
Not apart from 5th and 7th December. It can be on
6th.
Yes, 6th.
Well, the interim order will continue.
Yes, list on the request of the parties is a matter of 6th December. Interim order, when it shall continue till the next date.
Obligement.
7.
Your Lordship, I pray for some time, Your Lordship, for this matter.
Where is the senior? He's not here.
No, Your Lordship, he had got some difficulties, Your Lordship, he left.
How many matters are here? Only one.
Yes.
No connected matters this one?
No, Your Lordship.
Yes, as paid by the counsel, the petitioner this is matter after 2 weeks. Yes.
49.
Much obliged, Lordship.
Where's the photograph?
I have bring the affidavit showing the photograph, my lord, which shows that the portion A, my lord, is the landed property of the petitioner herself, which indicates that the front portion of the landed property, my lord.
Where's the photograph? When did you file affidavit? 20th October?
My lord.
This one?
My lord. A portion, my lord, is the landed property of the petitioner, for which
their shops in front, your shops.
Yes, Your Lordship. Actually, Your Lordship, this picture was taken by the respondent, Your Lordship. and it was taken in such a way, Your Lordship, just to mislead this court, Your Lordship. It does not disclose the actual person.
Then we'll get a local commissioner to go and inspect
My Lord, Your Lordship, I would like to produce a clear picture of Your Lordship.
No, then we can't, court can't, it can't,
Because
if you're
this
taking one
picture was
angle,
taken by
take
a
another
bit-
angle,
It was taken from top, Your Lordship, so it's
taken
clear.
from top and you take from bottom.
No, Your Lordship, because this picture is showing the
Taken from
actual
where?
picture.
My lord,
We can't go on like this.
There is also a civil suit. Which
Go
is
to
pending.
civil suit, let them do local
Yes,
inspection.
there is a suit, my lord.
File
Before the
application
civil
there.
court.
You have already filed, Your Lordship, but can you see my picture, Your Lordship? You see, Your Lordship, there is E, Your Lordship. This E is the petitioner house, Your Lordship. And there is A. A is the...
No, okay. A is your house, right?
No. A is the shop, Your Lordship, and the tea stall of the petitioner. A is a shop and a tea stall of the petitioner, which was lying there for more than 15 years, Your
Okay,
Lordship.
that's your shop. Okay,
Yes.
fine.
Then E
And
is...
what is C?
C is the ingress of the petitioner, Your Lordship, which he...
Is the?
Ingress of the petitioner, which he constructed, Your Lordship.
This land belongs to the Shino.
No, Your Lordship. And this D, Your Lordship, can you see this D?
My lord,
This D, Your Lordship, is the community hall, Your Lordship, which probably 2 years back, Your Lordship, the respondent 4 took over this property, Your Lordship.
It is your land.
No, Your Lordship, actually it belongs to the block of Maslam, Your Lordship. But due to the fire incident, Your Lordship, then they lost the...
No, we can't decide on Binyota.
But
One picture shows from the top, another picture is from the...
But my ingress, Your Lordship, you see, my ingress has been stopped, Your Lordship. And can you see the other picture, Your Lordship? I have circled it, Your Lordship.
You took by drone?
Yes, Your Lordship.
My God. Very advanced villagers.
Can you see, I have a round circle, Your Lordship. After construction in my land, Your Lordship, then I started this portion for using for
So you
ingress.
can't go from the side of this community hall to your property? From here? From the
No,
line
yes.
where you drew D, you can't go. You can't enter your house from there.
No, Your Lordship.
Because
then why
They
do you build
completely
your own shop in front of your house? You
this-
block yourself. You made the shops. You block yourself when you enter your own house.
No, Your Lordship. See the house, Your Lordship. This house is behind this sea, Your
I
Lordship.
understand. This is your house. It's behind your shops.
Yes,
right.
Lordship.
So you build a shop in front of your house. So your own shops are blocking you from entering your own house.
But Your Lordship, this sea also is belong to the petitioner, Your Lordship, where she purposely left for the
Sea
ingress,
also?
Your Lordship. Yes, Your Lordship.
Then that is such a civil dispute. We can't.
my lord, there's also a civil case regarding with this, which is still pending in the before
No
the
orders
civil
have been passed.
court. No orders.
With regard to this
It's
ingress
still
egress.
going on.
Lordship.
When did you build your little shop here?
On 7 last year, Your Lordship.
The little shop. When did you build C?
Last year, Your
That
Lordship, on
portion, my
7,
lord,
Your Lordship.
that portion, my lord, is the landed property of the Dorbarshno, my lord.
Whatever it is, might be. But if he has been using this passage for years, then when did you build this little shop? When the case was
last year, Your
filed?
Lordship.
After the filing of the suit?
No, before filing out.
Before filing it, let's the reason, Your Lordship. After he constructed, the petitioner made objection. Then he threatened the petitioner to demolish her house. But the petitioner has left no other option but to file a suit. But
That is-
after being filed a suit, then he started harassing and insulted the petitioner by socially boycott petitioner, Your Lordship.
That is not the fact.
What village is this?
Tersat Ungse, Your Lordship. Tersat Ungse. Now the ingress of the petitioner has completely blocked from both sides, Your Lordship.
They blocked by themselves, my lord.
No, Your Lordship. You see, this sea is fall under the petitioner land, Your Lordship. So they left this place only the small portion for the purpose of ingress, Your Lordship. But then instead of
When you started building, why didn't you stop it then? Why didn't you stop the construction? When you started building this little shop there?
we try, Your Lordship, but nothing works, Your Lordship.
My lord,
That's the reason, Your Lordship.
if I may be allowed.
And after that, Your Lordship, we try to go up because there is a space after this shop. There is space from the south side. Then we try to go to use that but as soon as he saw that the petitioner used it, then he constructed a small fence which the intention to completely block the petitioner ingress, Your Lordship. So now the petitioner has no other way out, Your Lordship. Has no ingress at all now, Your Lordship. He has been completely stopped by the respondent, Your Lordship.
My lord, regarding with that portion, my lord, there's a civil suit. If kindly come to my affidavit.
Last affidavit?
Last affidavit, my lord, which is as Annexure B. This is the report.
Lecture B?
My lord, page 13.
Last affidavit is the picture.
No, my lord, previous affidavit, the first affidavit.
Page?
Page 13, my lord. 13.
Next should be order.
My lord, by the additional magistrate, in the second paragraph, my lord, also as per the IO report, he mentioned that the land claimed by the first party is also claimed by the second party to be a village land, and as per the measurement land entity of the first party, there appears to be discrepancy with the land they have claimed. That's therefore, my lord.
Your Lordship, this is based on the...
Moreover to that, my lord.
Your Lordship, this order was based on the police report, Your Lordship. But when the...
No. We're not going to... See, the thing is that if you want to go by basic law, is that if you're using that portion as a path for ingress, egress, notwithstanding anything else, now that has to be executed. You have to take back, to the time when that shop was not made there. And where was ingress, egress? Then the court has to decide accordingly. Because this is a civil dispute. Writ court, we can come for this court with the prayer that you've been socially ostracized and that they will be boycotted, and so that you'd come for protection of this court. Correct? And this court had passed orders, I think that time, asking the deputy commissioner or the superintendent of police to go and see that no untoward incidents happened. Correct? And they have said that there's no social boycott or that they are ostracizing you in any manner. Now you changed the complexion of this case by bringing in this path and this house and so on and so forth. These things you can agitate before we'll have it maybe on Monday or something. We'll pass orders directing the civil court, even division to look this matter and pass effective orders, even by causing a local inspection. This is purely civil dispute.
This is purely civil dispute.
Yes. We take these pictures back. Yes, this is matter on Monday for further consideration. Yes.
Item 50.
Highly overturned.
We'll pass on Monday. You both come.
My lord, my lord.
Regarding the mining matter.
Mining, Your Lordship. There are 100 hectare.
Area,
yeah, Your Lordship. They have filed affidavit. I have also filed rejoinder, Your Lordship.
No, the matter also is come for hearing today.
Yes.
We'll have it some other day.
Lordship. Your Lordship.
When should we have it?
It is for
first week December.
Lordship.
On the
Yeah.
pre-list for parties.
Much obliged, Lordship.